Memos. All memos are allowed. Just keep your memos and clearly mention if fresh orders after notice hearing. And if any last occasion you have mentioned it, just give the date. Here. But there is a difficulty because now it shows on in the week, 4th week it is crossed 100, 11th is 99, 18th is 50. That is the situation. As it always happens around the mid of the month, it reaches around 300 matters to be listed as per orders. So give your memos.
Hearings.
Press schedules.
That instead of telling it to me because I am not handling that.
Sir, execution case रे 29 तारीख रे warrant जो press admission में कर.
Execution ने पैसे deposit कर दियो to maintenance time. If it will be listed, then you'll be having difficulty. You do not have answer.
सोमवार से ना.
Deposit करी के आसन तो. It will be dismissed on Monday.
Sir, emergency
Which law that entered? Have you read the execution law? Execution is Supreme Court direction कौन? Yes. Spend some time in legal appraisal of your judicial whatever. Whenever a case comes to you, spend some time in appraising judiciary instead of making a speech without any basis. Do that. What is the time limit fixed by Supreme Court? 125. What is the decision? Yes. Yes. What is the decision? By a judge from the Orissa High Court, who adorned the chair of the Chief Justice of India. We are not discussing here individual problems. We are handling legal issues. What is the due amount?
6,000 per month.
Total due amount. This is the problem. I have not seen the brief. You are mentioning the matter. The difference between your preparation and my approach, it can be contrasted. On each aspect, what you want to submit, I have done some work. And there is no shortcut to hard work in this profession. I do the same thing, what you do. But you have one case, I have so many cases. And you are filing a memo for listing. One thing I can assure you that I will pass orders. This is 125. He is to be arrested. 125(3). Another bench, it was passing orders of arrest and detention. This court, division bench. We can't. What is the difference between a lawyer and a particular person who wants to not to do something? That's the difference. We are at a much higher level. I say we, with some degree of seriousness. देखो केवे एस्पेरियोस fresh उड़ा का छुट्टी पूर्व देखो है
ना I beg your lordship's pardon, my lord.
ठीक है sir.
I have filed a memo.
All memos are allowed, sir. But please understand that I told you.
My case is ordered because the type of this month.
Sir, no preference on basis of cases and lawyers. No one comes to here to court without urgency.
No, my
orally, I cannot make anything urgent.
Because matter and lower court is put up for the order on the 25th of this month, lordship. And before
that is not an urgency. Unless there is a lower court order, nobody files a TRPC, nobody files a WPC, nobody files a RPFA. Suppose I pass that order. Since the lower court has posted the matter, that is across the board, all matters.
It was the final.
Whatever. It has to pass the order, you have to challenge it.
But once the order will be passed by the
once the order will be passed,
case will be
a lawyer should file an appeal or revision. Not mentioned in the court orally. That you take out of turn, ahead of others. You can't break the queue. There is no such listing method.
I'm requesting
for that. No. Requests are not to be undue. Requests are not to be entertained. What others will think that this court is entertaining requests. You see, you are not having any favor from me. You have a right to no requests.
Yeah, I have the right, but my matter is the urgent because once the order
all matters. Once the order is passed, and heaven does not fall. it will be stayed. You have to do the needful. Again, the same problem as sir is saying. You are not making a legal in-one submission. So then there has to be a determination. It will be mentioned in the determination that wherever the matter is posted for orders, one bench.
My case is only for the.
Find out from the determination. There is no such.
Sir, I have written given the.
ଆପଣଙ୍କ ଲେଖା ନୁହଁ ହାଇକୋର୍ଟ ରେ ଯୋଉଟା ଆସାଇନମେଣ୍ଟ ତିଆରି କରୁଛନ୍ତି ଅନରେବଲ ଦ ଚିଫ ଜଷ୍ଟିସ ସେଥିରେ ଲେଖା ହେଇନି ଆରପିଏଫ ଟିଆରପିସି ଲେଖା ହେଇଛି ଯୋଉଠି ଲୋଅର କୋର୍ଟ ଅର୍ଡରରେ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରନ୍ତି କଣ ହବ ସେଟା କଣ ହୁଏ
I have the reason for the application that the.
ଆରେ ଆପଣ ଶୁଣିବେନି ଲୋଅର କୋର୍ଟ ଅର୍ଡର ଫାଇନାଲ ହେଲା ପରେ କଣ ହୁଏ ଆପେଲେଟ କୋର୍ଟ କଣ ହୁଏ
Appeal or revision. Appeal
ଆରେ କଣ କରନ୍ତି ଆପେଲେଟ କୋର୍ଟ ତା ପାୱାର କଣ ଅଛି
make the stay and the.
ଷ୍ଟେ ହବ ସେଟା ହବ ସେଟା ଅର୍ଜେନ୍ସି ନୁହଁ ତାପରେ there is a computerized system. There is another problem. We cannot entry and get it listed. It's not listening to us. ये problem आगुर होतला बोले से system withdraw कर दिया गया. When I started, it was possible manually होतला. Manual system में नहीं. से सब जगह fresh admission list करिए. I have told him. अपन को भी सर fresh admission ना. सब जगह fresh admission तो list हबो ही हबो. चेष्टा करियो. सोमवार और मंगलवार नहीं. नो 12. कंप्यूटर किसी सोमवार मंगलवार बुझु नहीं. Yes.
My lord, I beg your lordship's pardon.
अब डिबेट सर थिबो एथिरे एग्जीक्यूशन रे डिपॉजिट करंतु किछ अमाउंट. You must understand what you are doing. Don't spoil the case of your client. आपण जेतोले क्लाइंट आसी आपण कोचन जे मु देबी नहीं आपण जानतु हाई कोर्ट. You are not a henchman. Henchman कोन बुझछन? There is an alternative dispute redressal of street. लोक पाको जाजन से गाय किछ करन तो छाड़ दे. You are not that. You are an officer of the court. Partly you are glorified by that past. I mean the glory of the court. You tell him on his face, you have to deposit this amount. Otherwise, no respite.
My lord, I beg your lordship's pardon.
Page wise, sir, or fresh?
No, sir. One matter was heard and disposed of, but.
अरे one matter टा fresh था page wise.
Sir, गोटे order upload ହେଇନି ସେଇଟା 10/4 ରେ ହେଇଥିଲା ସେଇଟା ଟିକେ ଖାଲି just remind କରୁଛି.
अर्जेन्सी अछि कि आपनकर टिके पाइल अप हे जाईची मोर जो प्रिजर्व मैटर उडा एक्चुअली
नहीं सर अर्जेन्सी अछि माने म सेही मैटर रो रेफरेंस टा अन्य गोटे मैटर रे मु देबार अछि
से नहीं सब जाका मैटर कोन हैला ना गुडे आपनकर जेतु कोर्ट रे जोडा डिक्टेशन होची कंप्लीट हे पारुनी. It was some time further dictation and all these things.
Sir, 29th रे से मैटर टा अछि. I hope that before that it may be uploaded. I have given a cheat to the court master.
होची Wednesday.
Sir.
Hopefully हे जिवो.
Sir, I have given the cheat.
Revision and appeal ले गोटे जिंस अछि जे you have to pass some detailed order. So सेति पे आपनकर बधे गोटे मिसकेस थिला so that has not been given preference.
No, miscase data miscase रे dispose of.
आइए dispose of matter रे आइए now I remember.
आइए.
Dispose of matter रे आइए रे कोन किसी urgency नहीं बोली
सर सेटा आ गोटे केस रे रेफरेंस पे दबकु मो गोटे मेंशन को जस्टिस सतपथी कोर्ट रे
तो
29 रे सर अछि.
ओके
सेति पे मुटे मेंशन कर.
सेमाने भी ह्यूमन बीइंग सेमाने भी जे काम को
सर नहीं सेति पे मो ए पर्यंत करन आज चेक कली जते अपलोड हैन मु तेन करी मेंशन कली.
करेक्ट आई गॉट योर पॉइंट
सर 29 रे अछि तो
काले आपनकर जोतरे धरंतु रिवीजन रे स्टे अछि कि इंटरडिक्टेड अछि स्टे नथले भी केसुडा का पेंडिंग रहउची लोअर कोर्ट रे.
नहीं मो सर बुझु छी
Yes,
I completely understand the load of work.
Little bit contents of the orders are becoming lengthy. Pages are more. Dictations, redictations, corrections.
So, setting खाली 29 पूर्व जदी हे जिवो I'll be glad.
I appreciate.
Obliged.
Supplementary list, page 1, 3 to 5, page 2, 6 to 14.
Madam, item number 7. Madam, may kindly grant liberty to file a better application.
से आपनकर जजमेंट गोटे थिला ना
नहीं सेटा टीआरपी मैडम सेटा
खाली जो
liberty to file better application.
ठीक अछि पढ़ला बेले से ऑर्डर टा करे आई हैव टू पास ए ऑर्डर एडजर्नमेंट देखियो 8 to 14 15 16 17 to 20 21 to 26 27 to 30
29, your lordship.
29
Kindly be taken
after notice matter
to notice matter.
Nobody objection, lordship.
My lord, may kindly take it up tomorrow. Mr. Das,
tomorrow this makes when available so
Your lordship
29 तक Mr. Das केबे आसीबे
27, today evening he is reaching. Your lordship may take it on.
commencing सतीश कर दियो
29, 20.
नहीं डेट कले बहुत असुविधा होची तो डेट कले प्रॉब्लम होची जे the matter cannot be listed to understand suppose a direct matter on 27 the court is not happening or because the matter lying over the list gets inflated so सेटा कटिला फेर सीता पर ताको डिस्कस करन ता चॉइस नाही देयर इज जुडिशियल ऑर्डर
Commencing 27 will be.
कोहाला ता बोल
Okay, my lord.
Difficulties is थोड़ा कोटा टाइप के आंसर है
थोड़ा कोट सर तेरा अपन तो
अभी
payment
फास्ट मैटर सुनले नी
आगे
आपण मैटर फास्ट मैटर सरी गला मेंशन नहीं सरी जाई जोटा सर मेमो दोथले तो आई रेस्पोंडेड टू सेही मैटर सब समस्त और सेही कथा
एग्जीक्यूशन में पेंडिंग दैट इज difficulties, my lord.
execution.
ସେମାନେ ରହୁନାହାନ୍ତି last time they are not represent before lordship. Again they are taking lower court time ଦିଅନ୍ତୁ warrant issue କରନ୍ତୁ. This is difficulties, my lord.
Payment दे लेते ना.
Payment का रूल सारा गला रूल से पास every month you are paying this
सर अवार्ड है जी 15,000 अपन 6,000 देने
15,000 का सैलरी तो आसी हाई कोर्ट को माने कहिबे मामू
my lord.
असुदे
Every month
सॉरी होनी सर आउट 10-15 मिनिट मेंशन हेले भी किछि इफेक्टिव ऑर्डर किछि हबन तो आसु
Definitely, sir.
किछि इफेक्टिव आवर नै
Then
28 रु 30 ला इन्फॉर्म योर सीनियर
my lord,
सत्य वी कमेंट इन सतीश कहले
सतीश sir.
होय सर
obliged.
मिलोड आइटम नंबर 8
आज्ञा
मिलोड आइटम नंबर 8
आइटम नंबर 8 वेट करो से पेज ता सरी गलानी जस्ट वेट टिके अपेक्षा करो
page 7 31 to 36
Page 7, item 34, my lord. In this case, both party appear before your lordship, my lord, matter already amicable, my lord. Try to amicable, so in this regard, file IA for place the matter before the mediation.
अमिकेबल सेटलमेंट पे स्टे रह रही
नहीं, mediation center file करूछु, appear करू both party.
स्टे पे करियो
नहीं, stay the हजूर आमे चाहूँ ना, आमे चाहूँ mediation center appear करू both party. आउ place the matter before the High Court mediation.
Refer to mediation.
Mr. Om Swarup for the petitioner, Mr. Jadev Behra for the opposite party. The matter being in the matter being listed in the list under the heading admission the single court royal comma is mentioned by the both the counsel for the appearing parties. Para it is submitted that the parties have agreed for mediation, which is a welcome development. Stop para. Accordingly, the records shall be placed by the registry before the coordinated mediation center for the proceeding with mediation. The learned counsel for the parties are requested to appear before the coordinated mediation center as you see. TC. On 3C3
both party appear करू.
party no sir. Upon Mr. Behra.
हाँ,
Mr. Behra केबे appear कर परिबे?
हजूर जेबे कहबा आज्ञा.
जेबे सर आपण हजूर कहले मु कहबी ना
सेही 30
30
हाँ 30 आज्ञा
तो कोना 30
आज्ञा
sir both the Lorded counsel are requested to appear on 30/4/2026 before the Lorded coordinated mediation center
30
shall
सेटा.
fix a date for appearance of the parties before the mediator Lorded mediator
सॉरी माय लॉर्ड 30 रे मो फादर इन लॉ चले नेक्स्ट वीक गेलो
adare first time जाउछन ना केबे
नहीं फर्स्ट टाइम एंदी तो नेक्स्ट वीक गेले हजूर काना बड़ जय हिसाब रे
तांगर कजिन जते फैमिली अछन फादर लिंगर मन रखंतु
नहीं मो होजी बड़ जय हेबी तो
सेटा लॉयर का भाई सेटा बहुत बड़ जिंस
कौन करिया
साइड रे
समय देई
they
पर
are an asset
समय
but I'm really worried about unmarried lawyers
समय देई पर आज्ञा कोन करिया आज्ञा
29 रे जिबे
ना से लास्ट से शुक्रवार
29 ना शुक्रवार ए मास एपटू पळे आसे
आज्ञा अप्रैल नेक्स्ट वीक आज्ञा एनी डे नेक्स्ट वीक
29 एनी डे 29 ଟା भी any day जे
नहीं नहीं आज्ञा मैं फर्स्ट वीक ऑफ मे
अच्छा अच्छा हो सर मिस्टर स्वरूप ताले 4 को रहू
आज्ञा आज्ञा
4 5 20 26 are
आज्ञा
you married Mr. Swarup luckily he is also he will understand your difficulties
संसारिक जीवन कौन कर आज्ञा डीपी
4 5 20 26 take कर दे the learned counsel shall also the parties shall be intimated by the registry oblique the mediation center. The learned counsel are also requested to intimate the parties. Yes.
डीप
The mediation report oblique interim report shall be placed before this court. Stop. Stop. No. On the next date of listing, the matter shall be listed for orders in the week commencing 20 July. कि 27 जुलाई कर दू
आज्ञा
आपनकर ता भीतर आ कोन कोन असुविधा हे पारे
भगवान न करू त्याव कुछ असुविधा न हो
यस चेष्टा करंतु सेटल हे जिवो
आज्ञा आज्ञा
My lord, liberty, if anybody party could not come, they may appear through DC before the
ये सेटा हमु कहले let us not intersect the procedure
आज्ञा
सब दिन रे जदी आमे करिबा सेटलाइज ने there is a problem
डीपी
Page 37 to 40.
so Swarup, usually what is the practice, are they appearing in VC? Because mediation the principle is, since you have raised this point, principle is that they should appear in person
but
because one-to-one interaction
yes yes
I mean, because mediation is not to disclose, it's not a case of argument or the view of the court, view of the parties. That is the reason the general principle is they should appear in person.
in certain case they could not leave their job
That is why I'm just asking. ମାନେ appear କରୁଛନ୍ତି but to start with encourage them to appear. ଆମେ ଯେତେବେଳେ ଏକୁଟିଆ କଥା ହେବେ when they talk one to one with the mediator, that should be because that should be in a environment where the privacy is felt by the parties. Yes. Anyway, you can move, but I just wanted to. Yes. Item 35.
Around 38.
38 sir कौन बोलते हैं
Pass.
I guess sir
Pass off.
38 टा पढ़ी बोल today there is a special bench notification कौन special bench पर है आरा bench yes
Item 1.
if you are stuck in one matter yes please
My lord, I am before this honorable court under 227 advisory jurisdiction, my lord.
so
Madam-
one matter is complete 10925 is complete
My lord, just गोटे लाइन ता भीतर खाली कहली
ठीक है
जोटा कि क्रांति साहू आ जो डॉक्टर बाबू भीतर थिला क्रांति साहू रो
last date of hearing कोटा था 24/4
आज्ञा बोधे 22
10925 data अच्छी 10925 और 2026 सुभाष साहू versus निरुपमा साहू though the matter is reserved for judgment to be delivered by order dated 21/4/2025 it is submitted by the learned counsel for the petitioner that since the other matter is listed together that is WPC 10928 of 2026 you will make certain submissions in the present matter. Prayer is allowed. Yes.
My lord, I am before this honorable court under supervisory jurisdiction, madam. And the pleadings which is incorporated in 617 petition, my lord, that is prior to 2015 and from and after 2015 pleading all present in my so not necessary to be elaborated, but through amendment I want to incorporated all the pleadings prior to 2015 both the party
Sorry, please again, please state again. You are saying that prior to 2015 the
Madam,
pleadings
both the
the
parties-
facts no just kindly listen to my query.
sorry ma'am.
Prior to 2015 you have reflected or
Again.
not reflected, you say reflected.
हाँ मैं नहीं किया सेटा 2015 रो पूर्व कथाटा सब दुई जण 9 वर्ष पर्यंत एका संगे रहिले
अपन amendment केबे फाइल कले
amendment
Please feel free to speak in Odia or Hindi.
Again,
Don't hesitate.
my lord.
Don't think that it's a kind of a status issue that you are.
No, my lord.
Please don't do that. Amendment filed on?
In 10925,
Hmm.
amendment filed on 9/2/2026.
9/2/26.
Again.
Okay.
10928 रे भी कोई
नहीं नहीं गोटे
again दुईटा एक संगे नहीं
अलगा अलगा करंतु so that आपनकर continuity रहबे.
again
Don't lose the track.
again
926 रे आपण amendment file कले. Order 6 rule 17.
again
Correct. So now you are saying in the amendment application you are bringing on record prior to 2015.
again
So the problem is that if you sat on oath or you argue, the amendment has to be rejected.
my lord, but
Because
in 2000
amendment, the precondition of seeking amendment is that despite exercise of due diligence,
my lord,
the facts which could have been brought
my lord,
and have not been brought.
my lord.
So there is I was just going through the case law. There is Modi, KK Modi versus KN Modi. So even it has been held if there are two parallel proceedings. Already one proceeding decided. The court has power to reject the pleadings in the same proceeding if the prayer is same.
Again.
So now if you say on 9/2/2026, 9th February 2026, you are saying the events prior to 2000.
In my amendment, which I want to incorporate in my plan, which is for divorce, filed by the husband under section 13 of Hindu Marriage Act in the year 2024, and after the taking evidence in one of the 125 CRP proceeding, then this fact came into the knowledge.
That has been noted.
My lord,
Your submission regarding the proceeding in the 125 CRPC, that has been noted.
my lord.
Yes.
So this fact came into
Last point you are
knowledge.
saying you had stated, but again you are reiterating that prior to 2015.
This fact, the Bengali Babu fact, and elaborately discussion, my lord may kindly see in my application, which I placed before a learned family court amendment
Paragraph,
petition.
application paragraph.
Just my lord, my amendment petition, my lord.
Yes, Order 6 Rule 17 paragraphs. Page 33 it starts.
33, Annexure 4.
Paragraph.
In paragraph 1, just I elaborately discussion, nothing any adultery or nothing any pleading is there, but regarding the responsibility that
Just
all
go
the
to paragraph so that we will be, going through the brief together. So refer to the paragraph.
My lord.
Para 1 you have said. Then
My lord, along with the plan, I just placed before this honorable court, my lord. Plan tray आगे देखो तो the petitioner submits that the marriage of the petitioner and the respondent was solemnized on this and dated इतना माने marriage केते बेले solemnized चला से सब discussion है जी तापर मु कहली para A सब para 3 ए जो A रो लिखा है जी ता पूर्व रो एटा ऐड करिया पे
ଯେତେବେଳେ କହୁନାହାନ୍ତି କି ପ୍ଲେଣ୍ଟ ଆଉ Order 6 Rule ମୁଁ ବୁଝି ପାରିବିନି
आगे
ଆପଣ para A of the Order 6 Rule 17
para A of order 6 rule 17
4A 4 capital A
नहीं para
proposed
A.
amendment
proposed amendment
4A
नो मैडम एटा para A सब para 3 माने मोर मेन जो प्लान टा annexure 2 रे मोर प्लान टा ता भीतर para 3A लिखाई जी द पिटिशनर सबमिट दैट
प्लेंट ର para 3A
आज्ञा
Okay. Yes.
प्लान रो para 3A ता भीतर मु कहली जे द आफ्टर para A एथिरे प्लान रो para 3A जोटा लिखाई जी ता परे ऐड करा जाऊ द पिटिशनर may kindly para 3 may kindly be add and mention fact that
4A ଯଦି ଏଇ କହିବେ ବୁଝି ହବନି ଆପଣ 4A ଆଡ୍ କରିବାକୁ ଚାହୁଁଛନ୍ତି para 3A ପରେ
4A नहीं सेटा खाली para 3
proposed amendment ରେ 4A para ରେ ଯାହା ଲେଖିଛନ୍ତି that would be added to para 3A of the plaint.
proposed आज्ञा
Yes. Product that. Roma, those who be cool and composed, don't miss. I'll read it.
Sorry, ma'am.
Yes, got it.
That the petitioner family earned
para pore of the so order
Proposed amendment.
Proposed amendment. As well as
Sithre mu mention kare chauchi je the plaintiff's family earned their livelihood through cultivation and lived under difficult financial conditions at the time of marriage due to monetary problems. My elder brother's wife delivered her child in a village hospital during that period, despite the need of manage household work and take care of my aged parent along with other family members. The opposite party, my wife, frequently quarreled with them. She did not cook meals on time, neglected the care of the family and her in-laws, and constantly taunt them. She often stated that since my husband was earning, no one except her had any right over his income. She repeatedly blamed my family member and told me that because of them, she could not live her life accordingly to her wishes, and insisted that I should leave them so that we could live separately away from village. So this is elaborate discussion because all the family problems or all the financial, financially situation achi, all this financial situation is soldering on husband.
Instead of reading it, your approach as a lawyer should be that you should sum up. This you want to adduce, bring on record as a instance of cruelty.
My lord.
Already para 3A in the plaint is there indicating cruelty.
My lord.
Correct.
And other paragraph also.
You must understand that if you have you cited that decision also, that if cruelty is already argued and plaint has been filed, there is no, concept of waiver form of cruelty like criminal law. Criminal law, one offense will find causing death of a human being. What is the minimum punishment?
7 years.
Have you checked?
No, criminal practice.
So, simply read the para. You'll be surprised. The minimum punishment is
10 years. Fine.
Maximum is
imprisonment for life or death penalty. Death penalty in
death
rare.
penalty is maximum. Fine is the other extreme. So there, because the concept is mens rea. So whoever causes death with intention of causing death, you'll see there are ingredients. But if in the standard of proof is proving to the hilt. This is a general discussion because since I have already reserved a judgment, so I have to bring it on to be mentioned. I can't keep the matter pending. So today we are again started hearing again at 11:45. So that you must remember. So this is a general discussion, not exactly pertaining to your case. For proving a civil matter, what is the standard of proof?
Beyond reasonable doubt is not.
So what is?
The allegation which is raised by the petitioner, the plaintiff, he must prove his pleadings, whatever he is submitting.
Preponderance of probability. Let us be pointed. So standard of proof is preponderance of probability. Second thing is that there is no graver form. Suppose less cruel. 13.1 is not satisfied. More cruel. 13.1 is satisfied.
But it is a
so
ground.
You must understand that. So when you have started reading the pleadings, that's the next point. Pleadings cannot be considered by the appellate court. Correct. Your perception. Now, if you say that I want to prove cruelty, suppose you have not taken the ground of cruelty in your original plaint.
Then liberty may be granted to file through amendment.
No. You have already done. You see your plaint now. Complaint. Page 15.
Page 15, my lord.
Yes.
There is nothing any pleadings regarding cruelty, my lord.
Please mark.
Para 3A, 3B, 3C, there is nothing any pleading regarding cruelty. And D is also, but in E, the last part of 2015, so when it is D re kahile that the petitioner and the respondent and their daughter resided in the rental house of Bhanu Sahoo.
Just let me go through, because if you are saying that you have not taken the ground of cruelty, there is a,
In para E,
so where is the order?
family court order, my lord. Annexure 1.
Any earlier order, when the petition was filed.
When the petition, the main plant or the
যেটা আরম্ভ হয়েছে সুটটা যেটা আপনারা প্রেজেন্ট কলে ফার্স্ট অর্ডার
first
প্লেনটার ফার্স্ট পেজটা কোনটা?
plant, annexure 2, my lord. Page 15.
The other aspect is that
My lord, then second.
just kindly listen, madam. So
Madam.
suppose now what you are saying, that you have pleaded in your plaint regarding adulterous conduct of the wife, and not stated the cruelty part.
Cruelty part is there,
Cruelty
but
part
not
you have
the-
not stated. You are saying correct. So now listen. Have you read the judgment on this, Justice Dalbir Bhandari?
Adultery part.
No. What amounts to mental cruelty?
Just go through 1 to 2 judgment.
Yes. So that's a leading decision of the. It's most often cited decision. They have gone through Taylor and Taylor, all these foreign decisions, and they have cited. So adultery is also amount to cruelty. This is the
Madam.
first thing. So your apprehension, you have to be sure to argue. You have to argue because now you are not in the trial court. This court lacks complete jurisdiction in entertaining a plaint.
My lord.
Please appreciate that. But still, I am discussing for the purpose that since you are rather very apprehensive and you are not happy with the way you have been told by the learned trial court. So that is the purpose.
No, my lord, there is much more evidence to my party
and
also.
before the sentence is completed by the
Sorry.
court, never open your mouth.
Sorry.
Because as I told you yesterday, human beings are not endowed with the capacity to understand by speaking. They can understand by listening to the speech. Cruelty itself is a cruelty. Adulterous conduct is itself mental cruelty. There is no difficulty. So whatever you have stated in para 2, look at your internal page, annexure 2, that is in MAT case 14.
My lord.
If you are able to prove whatever you have stated regarding adulterous conduct, that is enough. Prove cruelty. Correct. You need not have a separate, because the conduct itself amounts to cruelty.
My lord.
Now look at GH again, cruelty. Sorry, adultery.
My lord.
I is adultery.
Again.
J is
They
adultery.
is also adultery.
Adultery. Oh, kindly. I don't know whether pages are continuous. Page मध्ये भूल है, miss है ये. J पर कौन वो ही गला? KLMN. 17 पेज मार्क करंतु KLMN जोटा नहीं. आपनकर J होची cruelty.
Again. Like
J O आपनकर तुम्हें adulterous conduct, one adulterous conduct is enough. Now other जोटा is
but
misbehaving
that
with
must
you.
be continuous one.
Not.
Khali one time adultery is not,
Not-
is a ground.
So now you see the problem is that the case is yet to be argued. गुड़ा कहले आपण केतिर अछि KLMN अछि आपण तो क्यू देखुछन आपण why you are cruel to the court?
KL mo paghe भी नहीं मानते.
Court master has been cruel to court. 16 ପରେ 17 କରିला J रे आरंभ ହେଲା O रे J ପରେ कोन तापर ओ गोटी कहबे KLM सेटा नाही नंबर भी नाही ताको माने फिजिकल कॉपी भी नाही.
नहीं सर mo physical copy.
That's some mistake. Most likely आपनकर पेज मिस हो जाइछ.
Again.
You file करिवारे, that is the problem. तापर आपणकर ओ आ पी रे आपणकर से क्रुएल्टी अछि
ने पीरे डिस्कशन से जो समाज मीटिंग टा
कोन प्रॉब्लम होछि जे आपण सेटा प्रिपेयर करछन
आगे
बुझपारछन मु भी जोटा आपण सेत पई कहली जे आई डोंट हैव ए जुरिसडिक्शन टू डिसाइड द मैटर
माय लॉर्ड
and when is the matter is to be argued by the other side, perhaps ideally I should not discuss
माय लॉर्ड
because either way it has to be decided. If it is cruel or not, if I say now it is cruel,
No,
discussing
that
in
is
the
not-
court I should not because why should I delve into those issues?
माय लॉर्ड
क्यूटा पढ़ो पेज 18 जहाँ तो मिसिंग मिस एटी तथा जहाँ अच्छी पढ़ो
again
क्यू
Q.
क्यू क्यू रू पढ़ो
that the respondent has committed cruelty to the petitioner by leading an adulterous life and physically assaulted the
So
petitioner in
this
presence.
I was reading with you. It is not prepared. So at times it appears that I am fully prepared and I have gone through line by line. So exactly that ground has been taken. So lawyer has done the correct thing. Slowly पढ़िले.
Again,
Yes. आउथरे पढ़ो.
that the respondent had committed cruelty to the petitioner by leading an adulterous life and physically assaulting the petitioner in presence of caste gentries.
So that is enough. More importantly, just read further. And as such, concentrate karibe now. Whenever you are pressing a matter, just don't leave the page. Page para kyure kon achi.
Regarding the
And as such, she is not entitled.
she is not entitled for restitution of conjugal rights.
So
Section
that
9.
is your defense also to Section 9 application. So don't think that you have not taken the plea. Now kindly read R.
That the respondent has proved herself to be an unjust lady and leading a conjugal life, which such a lady is not possible for the petitioner.
What is that? That is cruelty.
Cruelty.
Kindly read further.
That the respondent has proved herself to be an unjust lady and leading a conjugal life, which such a lady is not possible for the petitioner. The conduct of the respondent itself disentitled her to lead a happy conjugal life with the
So
petitioner.
that is again you are saying because your defense in the Section 9 application is cruelty on her part, adulterous conduct. So that is enough. That itself is cruelty. So जो judgment Nalvin Bhandari का कौन सा है? Nilu versus Nilu Kohli versus they have summed up at the end. They have summed up 1, 2, 3, 4, 5, 6, 7, 8 instances of mental cruelty.
And recently also
So that is still the gold standard now. Up till now, in fact, only that has been reinterpreted. Whenever there is we have individual bench in MATA who have dealt with that. Now you can say false allegation of adultery is a mental cruelty now. Lodging of filing of frivolous cases is a cruelty. So apart from those points, everything has been discussed in that Kohli versus Kohli.
then
Always try to remember the matrimonial cases by the surnames. It becomes easier. Dastane versus Dastane, Kohli versus Kohli. That way. That becomes easier to remember. And I don't know, in exam, though it is tough to pass examination, even you don't give a citation, but you give the name, they give the marks. There is a purpose. The reason being, if you try to remember the detailed names, it becomes difficult. Kohli versus Kohli. Nabin versus Nilu Kohli. AI 2006 SC 1675. So this cannot be the subject matter of this application. Again, I'll say, because it is only 227, Order 6, Rule 17, that much.
Madam, may kindly give
So
liberty.
you must understand now that how you will conduct a trial. Never try to cross the bridge before it comes.
Madam,
Be patient with your approach. After the other side, you have filed 30, let the other side file and take help from a senior lawyer who is in the trial side.
there is much more.
And I have been told as a judge, general discussion, never ask questions in a cross-examination. Actually not told because I am not asking any cross. I am not doing. So, I mean, a very, very famous judge of India, he was just discussing that whenever you do not have an answer yourself for examination, don't ask. But the way you are progressing, then why? What is the golden rule? Why not to ask? The golden rule is that if you fail in cross-examining the other side witness, you are unable to elicit that answer, then your case is in trouble. So be less. The way you are going, you are raising so many points at a time. Because your allegations, the onus and burden of proof is on you, the plaintiff, husband. So once you are sure that you are able to prove whatever you have alleged against the first adulterer, enough. Because so that is how I introduced the subject of standard of proof. Preponderance of probability you have to prove that much.
But
Correct.
only through amendment.
No, it cannot be done by amendment.
Then,
So that is how I brought to your notice. See the plaint. You have already, in fact, you have already stated so many things, so many allegations against the wife. That is more than enough to prove mental cruelty as well as adultery. Desertion, I don't know whether you want to plead or you may plead desertion also.
I want to plead, my lord.
Okay, it is there. It is there. It could be there. So now.
And 3B.
Have you read S?
As from my main plant.
Yes.
As
that means actually. In the pursuit of thinking that you can improve the plane, you are not concentrating on the plane at the first instance. And that has created problem for you already. First point is it cannot change the nature and character of the suit. If you want to bring in another adulterer, alleged adulterer against
but
to be having
prior to that
whatever. So now the proof changes.
No, prior to that, this is the ground of mental plurality.
Please appreciate this. Wife W is having an affair with A and B. Having affair with A is enough. After filing of your plaint and you file your evidence, now you file a amendment saying that she is also having with B.
Prior to A.
Correct.
And that is the main cause.
That creates problem because in the timeline on 9/2/2026, you have already filed that, stated before the court on oath.
But evidence
so now suppose why one should spoil his own case? That has been bothering me in this part. If you want to prove it against first one, enough. By bringing in the second one, you are diluting against first one, also diluting against second one. Because these will be, I told you in a lighter vein the other day, but it was partly serious. Any smart lawyer will advantage of this because these are now on record on oath.
But in
because please understand. The other side will have a chance to defend herself. It is not ex parte suit. It's not ex parte proceeding. So they will have their liberty. No, it cannot be curtailed. It cannot be curtailed by any method.
But whenever any allegation,
so by bringing on record earlier allegations, you are opening that area. That's a very sensitive area. That's a very sensitive area. And there is another difference in adultery, which I am not going to tell you now. Because if I discuss as if I am discussing as a lawyer, I'm discussing many things which I should not, in the sense, because these courts, whatever is observing, it has a bearing on the case. Can you be sure that the other side is not watching? May not be, or may be watching. It may see, other side may watch. Maybe. So that should not happen. Because are we advising the case to be conducted in which manner?
No matter.
So that you should take care.
So
plain 3A, 4A, you are saying add 4A to para 3A.
Para 4A. Para B.
And now, if you insist, I'll record that you are saying cruelty ground has not been taken, but you have taken cruelty ground. I wanted to point you out. So the
Elaborately not
problem is,
discussed, my lord.
sorry,
Elaborately not discussed.
elaborate. You cannot take the
prior.
problem. You have to source. You have to adduce evidence for cruelty. That much.
Madam, then give just
And
liberty.
please remember, Madam Sharma, whenever you are attributing any personal knowledge to anything, especially of any in person, you have to procure his presence. She has to be tested before the court, or he has to be tested before the court in presence of the other side. If you read Evidence Act, and the other side has to have a liberty of examining that witness.
Yes.
So if you pile of 10 persons, 10 instances, where the onus and burden of proof lies? On whom?
Onus lies on me. Who is the same?
Burden is also same.
My lord.
So that creates a problem in the case. That is the reason I was telling you that experienced lawyers, they ask very less questions. They raise very few grounds.
But
Because one day, Mr. Lenka was saying, Mr. Lenka was present, somebody said that I cannot prove this.
just
He
appreciate, my
just
lord.
simply said that why did you file that plaint then?
That plaint-
So now you have a difficult task. Regarding whatever allegations were there, you have to prove that. Amended pleadings, you have to prove it. There is no question, or there can't be any two opinions that without proving the allegations, the matter will proceed. In the sense, not proving it, you will lay the evidence. In order to prove, court may be satisfied by applying the principle, or in the Evidence Act, or Nagarika Surakya, whatever is now. No. So that way you have to think in those lines.
But my lord, one difficulty is there. Trial court is based on, my lord, facts. The fact which is stated in my plan, I confine to that much only. Beyond that, I do not have any.
There is nothing left in your plate. Adultery and cruelty is already there.
But not elaborately discussed,
The
my lord.
instances of cruelty, already what you have. Sorry.
No.
Instances of cruelty, whatever you have narrated, that is enough.
My lord, give me a liberty to file a better application. Family Court Act and 151 CPC along with 617, my lord.
No.
This petition is confined only 617, my lord. That's why.
There is no concept of amending a order 617.
No, my lord, give a liberty to me to file a better application.
That cannot be granted. Because you see, whenever two parties are coming to court, both are equal. There is no one a lesser mortal. Let us assume.
Notice
Madam Sharma, just appreciate this. I have a suppose, assume. Please assume. Well, easier in the sense, more convenient also for you and me, that I will not discuss and pass orders. But when you are making a submission, I will reject it. I am telling you the reasons. Because at least I have shown you 8 paragraphs where you have elaborated the instances of cruelty. And I have told you that adulterous conduct is itself a mental cruelty.
Madam.
So all these things, how can I accept your contention that the husband has not taken the ground of, because elaboration of a ground, somebody hits the husband at Suhela in presence of others. Date is given. Enough.
Kindly in my amendment petition.
Because when the lawyer was changed, I think the lawyer you never discussed with the other lawyer. What was how he thought it. He has thought it. Apparently. And he has thought it with certain, what you call microscopic approaches. Because what I was telling you, that adultery itself is a ground of mental cruelty, he has specifically stated.
Madam. Para J, my lord, page 38. regarding the income of the petitioner. That is not stated in my plan.
That will come in section 24 or 25. That stage has not come. Again, you are crossing the bridge before it
Again.
comes. After 2021 discussion of Rajneesh versus Neha, the
Assets
court has
and
to
liability.
assert- the parties have to file assets and liability. Court has to adjudicate. Court has to. It's a duty cast on the courts.
They already filed by me.
So that also, if you want, you can seek amendment because that is factual. Suppose you say that this part I want to amend in that. But the problem is that why you are hurrying up to section 24. 24 CRs filed.
No,
Interim maintenance, penalty like section 24.
my lord. And
So then the occasion has not come.
but whenever in my man
No, no.
plan is
You should wait actually. You should wait for the things to happen so that because you cannot, prejudge the issue. As a lawyer also, how to perceive? How do you perceive? Then I have to observe that though you have stated in your plate regarding the instances of plurality, but still you are saying that instances of plurality have been stated, and that will say, well, it is very clear from your plate at the first instance that you have stated regarding the plurality. I appreciate this aspect.
only I submit before this honorable court that is not elaborately discussed, and that's why this amendment is necessary.
Discussion
But
is not necessary. You have to be specific. It is just the opposite of elaboration. If you start giving everything with basic pleadings,
Then Malad may kindly
whatever material is there, you have to prove it.
then Malad may
Wanted and specific instance is better. Wanted and specific instance is better. And whatever you have placed on record, that is enough. And suppose after filing the affidavit, the petitioner doesn't want to prove it. It is his responsibility. Lawyer cannot do anything. Is it your job to find out evidence?
no. Whatever that
But you can
pleadings,
seek for it. It's for him. Whatever he has stated, he has to prove it. That is the difference, sir. Please appreciate that also. You are not finding out. That happens in OTT platforms. The lawyer is sent to find evidence. That can happen. In trials, the junior most lawyer is sent for evidence, or the lawyer is searching for himself. That character of a lawyer, perhaps you have to reconsider as whether it is within your job to find out evidence. You should not, get overburdened with those kind of thoughts. It's only a suggestion.
No, but the-
practice. Don't get overburdened that whether you will be the petitioner will be having the evidence or not. It's his job.
no, whatever the facts that is placed by me before the court, this is my job only, madam.
Yes. So now 10925 is over.
Para D, my lord,
Where you
After
are reading
complete-
para D when you are referring? Para D
page 35,
amendment.
amendment.
That is 4D. Proposed
Madam.
amendment, the capital D.
Capital D,
Yes.
proposed amendment.
You want it to add
After
to
completing BA, final examination, my requested me to allow for education, all these things not incorporated in my plan, madam. And take admission in BEd course. I spent about rupees.
you should have read the plate before preparing the order 6 rule 70.
That's why, madam,
Because you are
give
creating a
liberty.
situation where it has become a thesis. The law is not requiring a thesis on adultery or cruelty. Law requires evidence. Enough. That is enough. In fact, what you have stated already, my wife started refusing physical relations with me, that you have stated in your original plate. Yes, anything else on that? At least you should be satisfied now. We have spent another 45 minutes. Even if I have reserved the judgment, Till 45 minutes we have spent.
My lord, only Madam, kindly give liberty to file a better application as per Family Court Act, my lord. This much is
Where? Which better application under which provision?
under section 10, read with 151 CPC.
No.
Under section 10 of Family
Already order 6 rule or section 10 of CPC.
of Family Court Act.
151 is not strictly applicable to Family Court Act.
Once 151
That-
is applicable to Family Court because CPC is
One judgment I have seen, but anyway, let us.
CP 151
ଆପଣ order 6 rule 17 ରେ ଆଉ କ'ଣ କହିବେ?
मैं चाहूँगी kindly
ସେଇଟା
give
ଆପଣଙ୍କର-
liberty
I
this order
cannot
to
be
court.
alternative dispute redressal mechanism.
My lord, I just
Alternative
pray,
redressal mechanism is different.
my lord, I just pray before this honorable court to file a better application or seeking liberty, file a petition under section 10 of Family Court Act, read with 151 CPC.
No. Order 6 rule 17 ଆପଣ କୁହନ୍ତୁ. Let us confine to your discussion now that you are challenging the rejection of your order 6 rule 17.
My lord,
So leave it there. Beyond that, whatever you want, because I cannot, because that has to be there first. ଆପଣ କ'ଣ କରିବେ ସେଇଟା, whatever petition you file, the court will deal with it. If you are agreed, you can challenge it. And we have been discussing today. 3-4 occasions I have told. I cannot predicate things.
my lord.
ସେଇଟା ଆପଣ representation disposal board କୁ ପଳେଇ ଆସିଲେ.
नहीं representation,
CPC representation provision ନାହିଁ.
এটা representation नहीं, my lord.
Liberty may be to move a representation before the trial court.
No, my lord, that is not.
We are heading towards that, but I have not evolved to that level. Liberty may be granted to file application before.
But better
ଆପଣ
application, my
ଯୋଉ
lord.
provision file କରୁଛନ୍ତି order 6 rule 17, read with 151, fine. That's all. So yes, now come to the second petition.
Second petition filed by the wife under section 9. In that petition, I filed WS, and in my WS, I want to incorporate this amendment.
So first you list WS.
My lord, same thing. Pleadings are both.
Page 21 of your brief.
My lord,
Yes.
page 21 is in my brief, and amendment petition, page 42.
I've got 21 টা place করো.
Again, page 21, that there is no cause of action for the proceeding and such the same is not maintainable. Maintainability ground, then solemnization of marriage.
Either not maintainability. Cause of action is different.
No cause of action.
and maintainability are different things. Yes. But sit out a default clause ଥାଏ. Even if maintainable, but as a precaution, ସବୁଠି ଲେଖା ହୁଏ not maintainable, no cause of action. Yeah, perfect. Now read 2.
That the amendment made in the petition in para 1 that the petitioner and the respondent are legally married wife about their the whatever the stated in their planned married life, husband and their marriage was solemnized on dated this that the parental home of the petitioner
So
at village.
you want anything change in para 2?
No, my lord.
You should not. Why you should not
2.
para 2? Para 2, who has filed the written statement, whoever is the lawyer has done the right thing. Because if you
Marriage is already admission by both the parties. Admitted.
that I'm not asking. If you dispute, it will be problem for you. That I'm asking you.
No, nothing in dispute.
If you dispute, what would be the problem?
Because whenever I file a divorce case in 2024
When you
and
have
accepted as a wife.
already filed section 13, if you enter into that arena of disputing the marriage or in any
No,
manner,
there is nothing in
so
dispute.
that will be problem. So the second paragraph is correct.
Madam.
3,
Para 3, that the amendment made in para 2, the petitioner that are
para 3 is again correct.
Hmm.
Yes. Then 4.
That the liability and the capacity. The articles which they said that I brought, these are totally denied. I think other articles to her and their ability and capacity, whatever they stated, that is denied.
Correct. So factual denial is there.
Madam.
written statement should be kind of a plaint or a denial or what? What is your concept of written statement? Have
Written
you checked
statement.
CPC? CPC ଆଣିଛନ୍ତି ଆଜି ନା ଆଜି
ଆଜ୍ଞା।
ଦେଖନ୍ତୁ anyway ଆପଣ ଆଗ ସାରନ୍ତୁ ଠିକ ଅଛି para 4 ସାରିଲେ ଠିକ ଅଛି everything has been denied para 5 now take para 5
That it is submitted that the marriage of the petitioner and the respondent was solemnized on this and the village itna and after the marriage the
5 is also perfect yes
as a school teacher sir which is about 1 kilometer away from his native village. After that I made amendment para 5A in my proposed amendment annexure 5 page 42
ଆପଣ 5 ଦେଖନ୍ତୁ ଆଗ ପ୍ଲେଣ୍ଟ ର ପ୍ଲେଣ୍ଟ ର 5 ଦେଖନ୍ତୁ
again
पेज पाइले पेज 16 रे अछि पेज 16 औनांती आपण धरचंदी कोटा
again
W50 10928
page 15 man
हां para 5 देखନ୍ତୁ
para 5 that the respondent on dated 24/12/2017
तो सेथिरे ओटा एलिगेशन अछि असॉल्ट रो लास्ट टू लाइन से हला assaulted
assaulted
pulling her hair and
by the pulling her hair
petitioner to go to Kanchanpur. So now you just look at the written statement. What is the reply?
Kanchanpur for about 2 years and the respondent was
आपण actually parawise reply सेटा तयारी करि नाहंती.
again
Whoever has prepared.
about 2 years and the respondent was working at just
Then from paragraph 8 onwards, paragraph 9 onwards, rather, you have stated regarding the instances of adultery and cruelty.
again para 9 10 and 11
No.
para 9 that the last
10, 11, 12, 13, 14.
again 15
also.
Again.
16 also. So, in case of second application, when you bring the defense is, she is herself cruel, so she cannot insist for resumption of restitution of conjugal rights. You have made a specific, taken a specific stand. देखो para 18 अपनो dire consequence everything you have narrated. Then 19 also. 19 and 20 again you have stated that she is not entitled due to her adulterous conduct. 21 देखो अपन सेटा नहीं चंदी जो
that is
वैसे समाज
and para 22 also.
So whatever you have stated, it is elaborately dealt with. Now suppose you are unable to prove those paragraphs in your defense, then why should you add more? If you are proving enough in your defense, adulterous conduct, instances of cruelty which you cannot sustain, and the matrimony did not be restituted. That's it. Because it is your section 9 defense. Then look at 22.
22 also. Committed cruelty by respondent leading adulterous life.
Physical assault. Again, you have stated.
But not a specific date and.
Not necessary.
एमती कहि दी एमती हेइथिला एमती कोर्ट तो कहिबे कि वेरी स्टेटेड दैट स्पेसिफिकली
आपण विटनेस कोन कहिबे
ताले मु जदी प्लांट रे नहीं ताले विटनेस
आपण विटनेस को जोटा आनिबे उसको आनिबे आपण सेटा आपण विजुअलाइज कर पार नाथि बोते
आगे
आपण विटनेस को आनिबे विटनेस को आनिला पारे विटनेस ताकर कहिबे से वकील द लॉयर बंद करो ଆପଣ ଏଥିରେ exhibit mark କରୁନାହାନ୍ତି।
এটা मतलब ଅବିକା ପର୍ଯ୍ୟନ୍ତ ଷ୍ଟାର୍ଟ ହେଇନି।
ସେଇଟା ତ ଆପଣ ପ୍ରଥମ ଦିନ କହିଥିଲେ, କିନ୍ତୁ
ଆଜ୍ଞା।
ଆପଣ ପଚାରୁଛି ଆପଣ ମୋତେ ଉତ୍ତର ହିଁ ଦଉନାହାନ୍ତି।
ଏଭିଡେନ୍ସ ଷ୍ଟାର୍ଟ
ଯେତେବେଳେ ଆରମ୍ଭ ହେଇନି, so why you are prejudging ଯେ କଣ material ହବ, କଣ ଆପଣ ଶୁଣନ୍ତୁ, ଆପଣ exhibit କରିବେ other side କରନ୍ତୁ। Object of conduct in cruelty to you. Our conduct is cruel to you, and our relationship is adulterous with another person. Those 2 likes and words is enough.
But
You don't have to make a thesis in a written statement, because you have to defend.
the same thing
So
which is
if you adduce evidence of cruelty on her part and adultery on her part, that is enough for you. You have already stated I have quantitative, because while drafting the petition, have looked at your written statement in session and everything. And more you invite the court to adjudicate, more number of pleas are rejected. That comes a problem, because simply the court has not rejected your claim.
no.
It has not rejected your evidence. Court says whatever is there is there. Let us have a trial. That much. Even if you are finding the court to be somewhat prescribed. Yes. If you find that the court is somewhat hostile, but still the court has not passed any adverse order against you.
That
And 125 you should not mix up never with 13.
the party has a highly apprehension that he will not get justice. That's why
Apprehension is always bad.
no matter
I told you,
to the conduct, because
even somebody having a feeling regarding the judge that the
no,
judge.
madam, because just sorry to appreciate, madam. During the time of cross examination also, despite of my
Again, 13 आरंभ ହେଇନି, but the problem is that ଆପଣ
13 ଆରମ୍ଭ ହେଇନି।
please 13 ରେ ଆପଣ ଦେଇଛନ୍ତି statement ଆପଣଙ୍କର
ଆଜ୍ଞା।
examination in chief ରେ ଆପଣ affidavit ଟା ଦେଇଛନ୍ତି।
ଆଜ୍ଞା
Affidavit on oath, what is your examination in chief?
only
ସେତିକି। ତାପରେ ଆପଣଙ୍କର ଯେତେବେଳେ ଆରମ୍ଭ ହବ examination, ସେତେବେଳେ ଆପଣ ତା ଛଡା ଆହୁରି add ବି କରିପାରିବେ। Must understand. It will be added to that.
again
Don't get obsessed with 125 proceeding. 125 proceeding is heavily loaded as far as payment of maintenance is concerned against the person who is denying maintenance. That you must realize. But 13 is something different. 24 is different. Now suppose there is a total maintenance pendent light. 125, whatever you have paid, that will be adjusted. But that patience you should have. I mean, your client should have, lawyer should have. That even if somebody is paying, have you marked that many cases where ultimately the divorce is allowed? During pendency of the case, Section 24 has been granted. 125 has been granted. All those things are granted, but that doesn't lead to a conclusion that Section 13, the divorce is not allowed.
no
That's not the case. So you want 10928 to be you'll still place that for we have already taken hard another 15-20 minutes your section 9 written statement. Still you want your written statement to be amended, or you go by the order of the court? Because now, sorry, please place now the impugned order. Page 12.
page 12 madam.
The finding ko padha asunto. Page 14. Peruse the petition now.
Peruse the petition filed under Order 6, Rule 17 CPC, and the case record in hand. It is seen petitioner wife has instituted the suit under Section 9 of Hindu Marriage Act with a prayer for restitution of conjugal rights with the respondent on dated 8/1/2024. Respondent filed WS.
On 18-1 is a different, sir. Yes, please carry on.
WS and subsequently the same was accepted. Petitioner wife 7/10/2024 has already filed her evidence in chief in safe of affidavit. Subsequently, the respondent on 9/2026 filed above petition under order 6 rule 17(7) CPC, but 17 CPC, seeking necessary amendment in the WS, in the amendment, the
ଆପଣଙ୍କର ବହୁତ ଜାଗାରେ order 17 rule 17 ଟା 7 ହେଇଯାଇଛି
I-
ବହୁତ ଜାଗାରେ
Sir, type post.
କି ରାଉରକେଲାରେ ସେଟା 7 କହୁଥିବେ
No, that CPC is so
Okay. That's in a letter. Yes. Seeking necessary amendment in the WS. Yes.
amendment, the respondent has made a new claim, that is why the petitioner has extramarital affairs with Bengali Babu Dakwar, but his above allegation was not found place in his original WS filed on 18
So leave it there only. So the court has done a grace to you. You must realize that because at least I am reading with you. I was reading your written statement. The court has done, because court is uniform. Please, even if you are so annoyed with the court, please mark the court is uniform.
I'm not.
Because you see, court says after she has filed her evidence in chief.
Much prior to that.
Correct. So after she has filed her evidence in chief for 7/10/24,
Again.
ଆପଣ 18 ରେ ଫାଇଲ କରିଛନ୍ତି 18 ରେ WS 7/10/24 ରେ ସେ ଫାଇଲ କଲେ ଏଭିଡେନ୍ସ
19/2/24
ଆପଣ 19/2/24 ରେ ଫାଇଲ କରିଛନ୍ତି
Again.
you should have wait ଆପଣ ଭାବିବାର ଥିଲା you should have wait that whether now amending the written statement would help her or help you
मतलब एका दिन रे 5-6टा केस एका दिन रखी देबे ताले कोनटा हो से तो भी संभाली परिबे ताले कहबे नेक्स्ट डेट रे पोस्टिंग कर दियो ताले एमती करी कि से डेट टा जाउचे माने टाइम स्पेंड ऐसे होता है माने जो दिन 125
WS proposed amendment and order. Is he scared of Kranti or what? The client is scared of Kranti, the adulterer.
obviously
He's scared. Then he will be scared of Bengali Babu also. Bengali Babu also.
obviously
So then even this I did not want to ask you. But then what is the point in adding more enemies?
नो मतलब मतलब उसका लाइफ के ऊपर जब हुआ तब जाके वो चाहे कि सेक्शन 13 कम टू पिक्चर
क्रांति को लाके खड़ा करके उसको प्रोसेस ज्वाइन करके प्रूफ करते हैं एनफ है अभी आप बंगाली बाबू को ले आए चिकन ले आए सब ले आए क्या
प्रायर टू
क्रांति को जो पूछना है पूछेंगे
हाँ प्रायर टू
आप बंगाली बाबू को पूछेंगे कि आप एक कटोरी में चिकन खाए थे
नो दिस इज गोइंग टू बी मेंटल क्रूएलिटी मैन
परेशान है क्रांति से तो परेशानी में बंगाली को भी डाल रहे हैं बंगाली बाबू
क्योंकि
बंगाली बाबू
वो मैन बेसिक बना था ये सब मैट्रिमोनियल डिस्प्यूट का
वो इनफैक्ट दैट अप्रोच शुड नॉट हैव बीन आई डोंट नो व्हाई दो I was just thinking that why after making a specific allegation against a particular person you want another person
नो
Now,
ये
you see the-
स्पेसिफिक जहां ऊपर एलिगेशन था वो
now अगर उनके उनमें मिली भगत हो गया तो क्रांति और बंगाली बाबू में
दोनों में हो जाए क्योंकि मैन
you should avoid that you should avoid a cooperation between both the adulterers
बंगाली बाबू
Okay,
मैन
see,
ड्यू
so
टू
that
दैट
so that is the bond नहीं रखे should have stopped. Because transfer can be allowed if you read 24 at any stage. You must understand this. You must understand this. Since last 2-3 days I've been telling you, don't ask for
Rest
because
educator-
it is not because the court cannot curtail it. Court cannot curtail it.
बट व्हेनेवर आई फादर पिटिशन देन
You have to be fair and diligent. Mention that earlier was Adjournment. That much. Because that brief is yet to be opened. You must understand, at the stage of fresh admission, the brief has not been opened.
But liberty has,
I mean, summary,
Liberty has-
summary withdrawal has matter to happen anything. Let us say the hearing concluded, judgment reserved. 7 Lekham. The matter is listed for fresh admission. It is submitted by the Ladakh Council for the petitioner that the petitioner wants to withdraw the present application. He further submits that the petitioner shall have recourse to the judicial remedy as should be available under law. Accordingly, the petition memo dated.
again,
Accordingly, the petition stands is permitted to be withdrawn. The petitioner shall have the liberty of redressal of his grievances in accordance with law. Call to next. The matter was hard for 1 hour 15 minutes. 11:45 to 1 p.m. I was saying lobby the thing.
Item 2,
Mr. Mahanti, you were kept waiting. That's a typical matter. So, Mr. Nirmal Chandra Mahanti for the appellant, Mr. Prem Kumar Mahanti for the respondent. R1. अब क्या अच्छा project proponent party करते थे Mr. Mahanti.
Notice was issued to BDA, my lord. Notice has been served on them as per the noting in the file. Notice has been, they have received the notice, but nobody has yet appeared, my lord.
Tell take a chance, please. Give some time. The matter is listed under the heading for referral to the special mediation drive. Appearance mediation drive 2.0 mediation for the nation. The Ladakh Council for the petition appellant refers to the order dated 10/3/2026, wherein notices were issued to the project proponent, Bhubaneswar Development Authority. Stuff. The office note indicates that the item delivered to the addresses. That is newly added OP number 3.
2.
2.
Respondent number 2.
Sorry, OP number respondent. Newly added respondent number 2. Awaiting appearance of the R2 list under the same heading.
on 3.
We commencing on 3 strong. Yes.
Item 3,
May please, your lordship.
Yes, please. Yes, madam.
Petitioner is the husband
You have appeared. Upon power achi.
on behalf of Amita Frit.
I'm sorry, I forgot your name.
Saubhagya Lakshmi Patni.
Miss Saubhagya Lakshmi Patnaik on behalf of Amitabh Tripathi for the petitioner. Yes, please.
Lordship, the petitioner has filed this application challenging the judgment dated 3/9/25 passed by the Learned Judge Family Court Noyagad in CRLMP number 144 of 21 to direct the petitioner to pay rupees 25,000 to the OP for maintenance. Lordship, previously the opposite party, the petitioner, filed a divorce proceeding.
Madam, one humble request. We are running short of time because one matter taken from the time. ensure that what you are submitting here was submitted before the trial court, matter of record, pleadings and evidence, because it is a revision. You must understand, revision is not an appeal, and this court cannot arrive at a different conclusion, possible different conclusion. If the court has followed, it is not a sanctuary of errors. Court has, evaluated the evidence and justice has been done. That much. These three considerations. What I was asking the learned counsel, that there is a leading decision on this. Criminal division, civil 125 is there, civil also the same principles. So if you start making a submission that whatever was not there, then the result is that, so after half an hour, then if I ask you, then the entire time is lost.
Lordship, can you see page 4?
Have you checked the written statement and the pleading and the evidence depositions?
Yes.
Have you checked? So
Lordship, the present petitioner filed already for paying rupees 20,000 to the OP.
So
as interim
has it not
maintenance.
been considered? So now the correct. Have you filed in your written statement that 12,000 is already being paid? It was within the notice of the court. Yes?
That's as per annexure 5.
Annexure no again I'm confused. Annexure mate problem about suppose I start dictating and said record city not my order is the Honorable Apex Court in that decision and non-application of mine by the High Court. I don't want that kind of a comment. I'm trying to my mind or not. Annexure एठी कथा पड़िनी आपण सेठी कोर्ट रे स्टेटमेंट देइथिले कि either in your written statement or in your evidence 12,000 and evidence also, and you have shown the court that you are paying 12,000 per month.
Affidavit of asset liability in filed by the present petitioner, whether any maintenance order has been passed by any court. Yes, rupees 12,000 per month in IA 21 by.
So you have understood the question. Now how the court has dealt with it?
London Family Court.
Yes.
Directed in the.
How the court has dealt with that statement of 12,000 being paid every month?
Annexure 5, page 81, let's see, order. In the result, the application.
The page 4, internal page 4, page 74 of your brief.
Yes.
Pile 74 pile.
Yes.
पढ़ନ୍ତୁ से सेंटेंस टा ଗୋଟେ ब्रेक हे जाईची मूळरू पढ़ନ୍ତୁ से सेंटेंस बुझ पड़छंती ता पूर्व पेज आरंभ होईची पढ़ନ୍ତୁ
There are no independent.
No. The petitioner also stated that file 73 the last word 5 lines, 6 lines.
Yes.
The petitioner also stated
Please.
तेस्तरी पुस्तक देखो.
Yes. Page 73, let's see.
Again.
The petitioner also stated that the OP is maintaining a very healthy life and his sisters are also getting married and his father is working as a demonstrator in Bargad College, Bologoda College, and getting more than rupees 80,000 per month. And he stated that his brother is a mechanical engineer and there are no dependents on the OP. In para 10 of her petition, the petitioner has narrated some of the incidents and events relating to the earlier suit of divorce filed by this OP petitioner against her under section 13 of Hindu Marriage Act and the IA. There was registered as 10 of 22 under section 24 of the Hindu
there too.
20,000 per month. After a proper hearing, this court awarded rupees 20,000 per month as interim maintenance to the petitioner, and being aggrieved, the OP moved to the Honorable Court in WPC number 26481 of 22 to Haram. Let's see, the petitioner further stated that the OP has withdrawn the petitioner as well as his earlier suit against the petitioner.
Further stated that the court lekha hai na? My lord, or the further statement. The petitioner further stated that OP has withdrawn the petition.
Withdrawn the petitioner.
Yes, भूल हो गया क्या? ये हमारा जो English भूलभाल English of has petition the petitioner हो गया. Petition as well as his earlier suit against the petitioner.
Against the petitioner and the temperament of the OP is anyhow harasser. The learned OP, the learned trial court directed the petitioner.
This is you are not you have not gone through the facts, you have not understood also. ଆପଣଙ୍କର କୋଉ କେସ୍ ରେ ଆପଣ ଦଉଥିଲେ ହାଇକୋର୍ଟ ଯୋଉଟା 20,000 ରେ ଆପଣ ଫାଇଲ କଲା ପରେ ୱିଥଡ୍ର ହେଇଗଲା ସେକ୍ସନ 24 ତାହେଲେ ସେକ୍ସନ 24 କୋଉଠି ରହିବ 13 ତ ୱିଥଡ୍ର ହେଇଗଲା
ୱାଇ ଫାଇଲ କରିଥିଲେ 24 ପିଟିସନ ରେ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନେନ୍ସ ରେ
କେସ୍ ଏଟା ଆପଣ କହୁଛନ୍ତି ଆଜ୍ଞା ମୁଁ ଫାଇଲ କରିଛି
डिवोर्स केस लॉर्डशिप डिवोर्स
नंबर କହିବେ ଇୟର କହିବେ ଡେଟ୍ କହିବେ ସବୁ
everything you have to say CP number 40 of 2000
order we have placed before the trial
annexure 5 रे लॉर्डशिप
annexure 5 no trial court रे कोठी ଦେଇଥିଲେ you must understand you are creating a situation if I start dictating then my order will be non application of mine because then you have to tell the trial court that in so and so CP pending CP रे आपण को provision ले दउछथि त
let's about the date 10 hours next to
13 टा withdraw गला पर आउट फेल करछथि
13 present 13 case pending अछि before the honorable
सेटा त आपण 10 थर कहले हम कोन बुझी पाउन आपण ओडिया रे भी कहछन ओ भी ओडिया स्टूडेंट मीडियम प्लान आपण ए जो 13 टा withdraw है CP आपण को CP and both and that petition was filed by you
I would date tellers also expected.
Had learned counsel for the petitioner at some length. The learned counsel for the petitioner in the marriage is before this court. Challenging the petitioner husband in the marriage is before this court, challenging the judgment dated 3/9/2025 passed by the learned judge family court Noyagad in CRL.M.P. number 144 of 2021. The CRLMP was filed by the wife in the marriage under section 125 of the CRPC. Into bracket, since repealed and substituted by perimeter provision under section 144 of the BNSS 2023 bracket closed. By filing the application, the wife in the marriage had sought for monthly maintenance at the rate of rupees 40,000. Per month. The present petitioner, husband in the marriage, did appear before the London trial court, contested the application filed by the wife, filed his objection of the written statement. It is submitted by the counsel for the petitioner hearing that the learned court has not taken note of the fact that the husband is paying rupees 12,000 per month. आपण केते टका देबे केते टका डिपॉजिट करि परिबे ट्रायल कोर्ट रे एग्जीक्यूशन फाइल हिची केते डिपॉजिट करिवे
इंस्ट्रक्शन
कोन लिखले per month pursuant to the direction of na janna andi
direction of honorable family court Noyagad.
Which case? Which provision?
24 of Hindu Marriage Act रे हमें regularly 12,000 paid करछ आज पर्यंत
अरे सर मैडम नंबर टा कहबे ना इन सीपी नंबर एते
CP 40 of 2023
in CP number 40 of 2023, out of which IA number
That's it, IA number 21 of 23.
IA number 21 of 2023 was filed by the wife under section 24 of the Hindu Marriage Act. It is submitted that CP number 40 कहले ना
40 let's see.
40 of 2023
of 2023.
40 of 2023 has been filed by the husband under section 13 of the Hindu Marriage Act. Para. Para, accordingly, the learned counsel was asked whether she had filed, whether the petitioner has indicated the said fact of payment pursuant to the direction in the CP in the written statement, and had produced the evidence before the learned trial court regarding payment of the amount every month as suggested. And what is the finding of the learned judge family court on that? C6 and has adjournment. Case matter.
2 weeks. Next week.
Again?
Next 2 weeks.
ଆପଣ ଆଜ୍ଞା ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟରେ ସେ ଆସ୍ପେକ୍ଟଟା ନାହିଁ। Written statement जो aspect ଅଛି 20,000 ଟଙ୍କାର, that petition has been withdrawn. Otherwise, no court, because you see, you must understand these are the level senior most judges. In many cases, many stations, since we do not have a concept of principal district judge, this family judge is a senior judge, very senior judge. This is the problem now. In fact, upon jemti confused, my order will be still more confused. Unless you bring on record what exactly your submission is, because you can't improve. Now, suppose you want to tell that court, then you have to tell that court, not this court. Am I sitting in the section 125 application? I am not. I am sitting in revision.
This is a multiple maintenance.
Multiple maintenance आपण सेटा कहिबो किए कोर्ट रे आपण multiple maintenance देई परिबे is your choice. Multiple maintenance is not a legal bar or illegal. Multiple maintenance uniformity has to be brought, that every amount is to be taken note of. That can be taken note of unless you tell the court again this amount is being paid, and the court has clearly noted that the earlier 20,000 application you have withdrawn. And that happens. As adjournment, list in the week commence, list for fresh admission in the week commencing, date after vacation.
That's it.
Before
2 weeks. 2 weeks after.
18 week commence 18
18 so the after the special bench, or maybe if Sumanti
And
Mr. Lekka will appear. Okay.
in the special.
So let us see. Or we can, I mean, if you seek adjournments, I'll mark those matters because.
My lord, item 22 requires some more time. So my lord may call this matter any other day. Item 22.
Well, page wise jiba. Jeti ki rohila page wise jab. Mr. Das, Mr. Arun Kumar Das, item 5.
Any other day.
Correct. ताले 5 रा fresh से रखिबे. Fresh टा टिके छुट्टी पूर्व रखंतु.
week commence 18
We commencing 18/5. इना पर जे तळु को नै जो से कोन हो राजस्थान का 3 नंबर रे अछि. First matter hearing.
My lord, item.
Just. Yes, item.
Item 4, my lord, no instruction has come.
Item for
Anjadeo, Mr. Yes.
yes, my lord. On behalf of
See what the instruction by कहउचंती. Press तो अछि आसु आउट दिन को.
again.
Yes. जारी करंतु आको डेट.
week commencing 29
On this
अरे नहीं आगे से और से चलिबो. हैं?
से 18 जाने
18/5 ଆପଣ ତ 300 କରିସାରିଲେଣି 18/5 ନା ସାର୍ 29 ହଉଛି ଆପଣଙ୍କର ଜଷ୍ଟ ଆଫ୍ଟର ରିଓପନିଂ ର ଫାର୍ଷ୍ଟ ୱିକ୍ ଆଫ୍ଟର ରିଓପନିଂ ଖରା ଗ୍ରୀଷ୍ମ ଛୁଟି ପରେ କଣ କହିବେ ଆପଣ ନହେଲେ 18/5 ଆଣିବେ ପ୍ଲିଜ ମିଷ୍ଟର ମହାନ୍ତି 18/5 5 ହଉଛି 18/5 ସ୍ୱାଇଁ ଆପଣଙ୍କର ତ ଫାର୍ଷ୍ଟ ପେଜରେ ନାହିଁ କିଛି
Item 18, my lord.
ନାଇଁ ଯାଇନି ସେଠି ଆମେ ଯାଇନି ପେଜ 2 6 to 14
Item 10 ଟା
10 yes sir
I
Amnesty
agent filed
matter
for
that can be disposed of.
dispose of amnesty matter.
हमने सीधा मेमोटा दियो
I've already
अच्छा आईए फाइल कर दी
Yes, yes.
अच्छा ठीक है नहीं काली गोटे से मेमो देले तो मिस्टर जेन्ना करो
I number 558.
amnesty टा डिस्पोज ऑफ आइटम 10 amnesty ऑर्डर जो हो काली इतना करो
Your lordship, I record my presence for OP5.
प्लीज डाकुच आइटम
My lord, this is copy.
प्लीज गिव नहीं कंप्यूटर सुविधा जे आपण नंबर देले भी हे जीवो नंबर डेट थरे आपनकर से डिस्पोजल जगह रे हे वाला ताल लाइव ओवर सेटा
मैं काई एटा देली गतकाली मेमो करे एटा आई
सो अभिलाष मिश्र फॉर द petitioner सर अमरेंद्र प्रसाद रे
Rest of the matter of this list.
सर तब ठीक अछि तले एटा बोइबे डाकिउनी मु पर डाक अगर मेंशनिंग सर यस आइटम 11 to 14 एटा आपण आइटम 10 रे रखो मते देबे डिक्टेशन
Item 15 minutes. If
Just
it
one
is not taken up today, let it come after vacation.
think this bench is not available and there is a noting that after the other bench this will continue so
The problem
that is unusual so what they got the note?
tomorrow for a month.
No
So
sir
let it come after vacation 15.
after notice matter no difficult
Item 15.
fresh matter to hearing है जो चेक कौन 15 टा डेट करो
कमेंसिंग 13
ଆପଣ 11 ରୁ 14 କିଏ ମେନସନ କରୁଛନ୍ତି
Item number 11.
ହଁ 11 କୁହନ୍ତୁ
Madam, let me check taken after 18/5.
ଅଦର ସାଇଡ ଆପିୟର କରିନାହାନ୍ତି ଆପଣ 1 लाख डिपोजिट करनाहांती
They will be deposited that amount we could not able to afford. So
ठीक है दैट ऑर्डर विल बी पास्ड ओके डेट करून से आफ्टर वेकेशन को
वो कमेंसिंग 6-7
we commencing 6/7 but that order will be passed that you have not complied that order you want further okay or you, I mean are you sure तो ना भूल भाल कहि देले
no, he will.
जानि से डिपोजिट करछंती कि नहीं आपन इंस्ट्रक्शन कोन अछि
He did not deposit.
नॉट डिपोजिटेड आपन को ना
Side to side Malik.
ओके पावर अछि एस मलिक आपन यस 12 सीरियल डाक दियो
आइटम 12
ठीक अछि
13 14
15 सांकर बीएन शांति सांकर केबे कहले आफ्टर
वो
वेकेशन
कमेंसिंग 13-7
13/7 आफ्टर वेकेशन
Because it is a lengthy matter, it will take some time.
16 डाकंतु
16
Item number 16.
Yes.
The IA has been filed, but it has not been taken on record.
hey see I am not passing any order so आपण एटा जाऊ ताले केबे को आफ्टर वेकेशन बिफोर वेकेशन कोंतु it will be listed along with the IA possibly आपण आए नंबरटा जानछंती
Yes.
गोटे दियंतु मेमोरी गोटे कागज लिखि ताकू दियंतु से पठेबे यदि नथि स्टिल डेट करो आपण
13-7 वो कमेंसिंग
we commencing 13/7 17 कोंतु 17 18
18, my lord.
yes
This is a pension matter, my lord. Counter has not been filed. My lord, counter is necessary in this matter.
18 आपण को ब्रीफ मिस्टर महांती
No, your lord. No, not mine.
डेट करो मिस्टर सेठ your brief
Yes, your lord.
18 he says that pension matter counter has to be filed
Your lordship.
22 matter Mr. Swai after vacation
Yes, my lord. Yes, my lord.
वो कमेंसिंग
but please take note Mr. Sethi though I am not
Yes.
passing order
Your
I
lordship.
have not read
I'll send a letter today.
आज्ञा
वो कमेंसिंग 13-7
13/7
Your lordship.
19 So भूया और थिले बोते 20 21 मिस्टर पटनायक
बिफोर वैकेशन
ठीक है ठीक है 21 मिस्टर बारिक
We come to 18/5.
18/5 yes Mr. Misra
Vacation ପରେ ଆସ
ଆପଣ ଅଛନ୍ତି yes after vacation
interim order was there filing
the interim order adjournment थिला
application देला extension of see
अच्छा ठीक है that has to be passed okay
Only item there is interim order.
the interim order जदि adjournment नहीं I am not touching it but since adjournment is specific date it has to be extended if it is a stay order I am not touching please appreciate I am not touching any matter also because unable to reach 22 after
We
vacation
come in 13/7.
13/7
23 after vacation.
please 23 करो तो फिर
We come in 13/7.
13/7 भी Madam Naidu
If before vacation also it's possible, after vacation as per my lord's code. As any date which is timely. Here only the affidavit.
after some time actually the listing specific urgent matters touches around 300 that becomes a problem around 15th of
Give it to my lord's
okay
code.
no other side has any difficulty
The other side, my lord, is taking advantage.
अच्छा ताहले आपण ताहले before vacation आणंतो
We come in 18/5.
Oblations.
yes 25
Before vacation.
करो डेट करो
18/5.
after 5 आपण एटा कंप्यूटर रे करछथि बुझले ऑर्डर केले पास हो 26 डॉक्टर लेंका पेज 6 आइटम 27 28 29 30
You'll also 30 any day before vacation.
before vacation how
We come in 18/5.
Yes.
actually up to 11th of he has crossed 200 must be thinking that why because he started posting on 4/7 week and sorry 4/5 re so this section that is the reason now he is only left with only one date को कितना नंबर आइटम कहता 30
31 before vacation. I am on BC Malad.
अच्छा हो ठीक अछि before vacation
We come in 18/5.
Malad.
yes then 32 33 34 35 36 34 ଆଗରୁ ହେଇଛି ହଁ ସେଟା ରେଫର ଟୁ ମେଡିଏସନ ଠିକ ଅଛି ମୁଁ ମାର୍କ କରିନଥିଲି ଅର୍ଡର ହେଇଯାଇଛି ମିଷ୍ଟର ପଟ୍ଟନାୟକ ପଢେଇଲେ ଲକ୍ଷ୍ୟ କରିନାହାନ୍ତି ତାଙ୍କର ଏଇ ବାଟରେ ଅଛି ଟିକେ ବାହାରେ ଦେଖିବେ ମିଷ୍ଟର ପଟ୍ଟନାୟକ ଆପଣ ଲୋକ ନାହାନ୍ତି ଆଉ ବସନ୍ତୁ ଆପଣ ଯାଆନ୍ତୁ କମ୍ପ୍ୟୁଟର ଛାଡି 38 39 40 ଯେତିକି ରହିଲା ଯୋଉଟା ଆମେ ଜଣେ କାଉନସିଲ ନାହାନ୍ତି ଦେଖିବା ଯଦି ମେନସନ କରନ୍ତି ହେଲା ତାପରେ ରିଜ୍ୟୁମ କରିବା
Item 10, my name is OP5.
sure
Item 9, my lords.
ଆପଣଙ୍କ ହଁ ଆଦିତ୍ୟ ତ ଅଛନ୍ତି
ଆଜ୍ଞା my name may only be
ଆପଣ ହଉଛନ୍ତି ଓପି କାହା ପାଇଁ
OP5.
ଆଜ୍ଞା
OP5.
ଠିକ ଅଛି
Item from VC, my lords. Item 9 may be taken up, my lords.
sir actually today there is another bench
No, my lords.
technically this bench is not available ଆପଣ
Lordship.
ଯଦି ଆଜି କରିବେ କହୁଛନ୍ତି ଦେଖିବା but after that bench the noting is after that bench it can be taken up
Lordship, lords.
ହେଲା ନହେଲେ ଫ୍ରେଶ ଆଡମିସନ ବିଫୋର ଭେରିଫିକେସନ ରଖା ହଉଛି ଗୋଟେ କୋଉ ଦିନକୁ ରହିବ
My lords.
no question of going out of the list ହେଲା
My lords.
ରହିବ
My lord, item number 8.
8 again yes
Item number 8.
sir ବର୍ତ୍ତମାନ now the time is over before recess I am not taking the matter but if you want you have to wait ଆଜି ନେବା ପାଇଁ ଚାହୁଁଛନ୍ତି
My lord.
you have to wait
Item number 6. There is a
ଆଜି
chance.
ଚାହୁଁଛନ୍ତି
I catch.
you have to wait I am not going out because the
Sure. 11.
Yes, Mr. Verma.
No, 57 I missed out.
Yes, at 37. You want a date after vacation?
No, the before that, the 18th May, Josh, empty management, that will continue. The time picture, the adjournment.
But item no
37, na?
Again, that's 7.
Total से 18 but item no 32.
Sir,
Item no 32.
32.
Right.
That will record over.
ସେଟା hearing ହେଇଥିବ other side ନଥିଲେ.
Hey, the matter touch करनी sir. This bench was till 1:15. We continued till 1:40, but I mean, touch करिनी. So आपन date चाहूचंदी ना working दिनों को post कर देबे. Any specific date you want ना कोन?
नहीं सेमिति तो किछि
तो आपन से जेतेटा मैटर रहिला जेटा मेंशन करि नाहंती बा किछि से कर देबे. किछि delisted होनी.
अच्छा.
But the delist करिवे.
ना.
Madam?
That's item number 16. We have a court has court has directed to file the IA. We have already filed the IA on Tuesday.
तो 13/7 को जाइछि सेटा कोन आसीनी कहले
जूनियर जाननतला से ऑफिस कॉपी टा टैग
देखो कॉपी दे दीचंदी आए.
We have already filed that copy.
कोर्ट फाइल करछन. जेरस काप देले.
एडी देछि.
एठी के दोचन.
से जानी पलन तो
जानि ना एडी दे दी. ना ऑफिस रे जो फाइल करछन
एटा आपण रिसीव करछन.
ना.
आपण एटा डब्बा पे चाहउछन. Understood. Order किछि हेनी एक्चुअली फाइलिंग रो किछि ऑर्डर लिखा है. Yes.
Document special.
Yes.
BCT.
Okay. Let's go to item 10. Kabilas Misra for the petitioner. Just catch your breath. Just give me a second. I'm just dictating one order. सेटा टी खुल देबे लिस्ट अच्छी सेटा और सप्लीमेंटरी टा Vilas Misra for the petitioner. Mr. Amarendra Prasad Ray for the number OP1 Union of India ପାଇଁ କି appear କରୁଥିଲେ ଅଛନ୍ତି ଏତେ ନା OP1 କରିଦିଅନ୍ତୁ ଇଏ ଗୋଟେ DSGI ପଚାରି ଲେଖିଦେବେ ଆଉ କଣ କରିବା ନିଷ୍ପତ୍ତି ଉପରେ କି ଅଛନ୍ତି ନା କଣ ଟିକେ ପଚାରି ଦେବେ ଆଜ୍ଞା ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ DSGI ଅଫିସ ଭିତରେ 2, 3, 4. Mr. Amarendra Prasad Ray, standing counsel. 5, Mr. Aditya Misra. Appearance right now. Say, order call for the item 10 about amnesty scheme is disposed of. Yeah, here actually, Item 11.
11.
Mr. Sai Prasad, 11 of the first page. Mr. Sai Prasad Malik of the petitioner. Also for the petitioner refers to the earlier the matter was heard at length from 2-2-2026.
Item number 6. There is a clear 6.
6 you want to place the matter. Actually, that page is not available right now. Just wait. These are the matters which has spilled over actually. They were done in the first half, but orders have to be completed. So that we sat till 1:40, but it could not complete the orders. The facts and the facts as well as the legal issues were noted in detail. Tough. Thereafter, 17-3-2026, the matter was adjourned on behalf of the petitioner, stating that regarding the observations made in paragraph 7 of the earlier order, 2-2-2026, we shall obtain instruction. Today, the matter being listed for orders is mentioned by the learned counsel for the petitioner. He seeks adjournment. To grant further opportunity to the petitioner, list in the week commencing 6-7-2026. Copy of this order shall be forwarded to the Judge Family Court Rourkela to be kept in the records of CRP criminal proceeding number 126 of 2022. Correct.
21.
Again?
21.
21. The matter, as paucity of time intervenes, the matter could not reach 21. And is mentioned, the matter could not be taken up. Stop. The learned counsel for the petitioner pays for interim order to be extended. Stop. The interim order dated dash is reiterated. The matter shall be listed in the week commencing 18/5. On a prayer being made, say the repeat kariye order. The matter shall be adjourned beyond 18/5 of the way 25/5. That would be convenient to the learned court in season of the matter. Separate? 37 would have mentioned. 37 is same. Yes, special call for specialist.
Specialist, item 1.
My lord, this is that matter, my lords, where your lordship had indicated that since your lordship had earlier passed orders, so to cut short the dispute, put it in a limited forum, limited compass, my lord, so that it will be easier. Let the officer decide. So we have also agreed and let it go back to the certificate officer. Let us be given an opportunity to raise all, my lords, legal issues at that forum. And then whatever time you have granted the other matter, and let that order continue in our favor. Only that. I had already submitted on
That I'm sorry. That order, other order was passed in the presence of the AG.
No, in that case, my lord, that the appeal was before the RDC.
Oh, here the.
Here he has not filed appeal. My
No,
land senior
I-
wants to remand the matter again to the collector.
Naturally, because that was my entire point.
So that we
At that stage only, I have been denuded of the opportunity to contest.
So now if he goes to appeal, what would happen? Any different?
No, he has not filed appeal, admittedly he has not filed.
Deposit of the entire amount, all those things will come in. Possibly appeal cannot be entertained without deposit. CORAM. No, first of all, they took out a certificate against a dead man. Then when it was pointed out, one of us appeared and then pointed out that you can't do it. So much of this substituted. 60.
60.
Yes. Page 33. Appeal from any original order may under this act shall each order as well.
50% is to
Yes.
proviso A.
Yes.
88 crores. My lord.
It will become
Osios. The entire remedy becomes.
No, that may be.
And there are other points I'm
And
raising.
the point here, my learned senior has said that no opportunity has been given and they have been substituted. And the case was instituted against the dead person. That is not absolutely correct. That is the record.
That is so. That if you have kind of go through that. So when did you when the substitution was filed? Give me 3 days. When the substitution was filed.
Your lordship will
show me the substitution application.
Yes.
Or the order in the substitution application.
Let me.
No application was filed.
I have prepared a date chart.
No. Only the date of filing of substitution application
Yeah.
and the order in the substitution
The substitution application has not been filed because prior to the substitution, actually, in fact, your lordship will find the original lease deed was granted in favor of one.
In a recovery proceeding.
Yes.
If substitution application has not been filed, then how the authority or maybe the judicial forum or maybe the administrative authority, how it proceeds?
The question of substitution does not arise. Yes. So that's why I have prepared.
So on the order.
Yes.
That what is the you have the order?
Because after the death of the original lessee, then what happened, my lord? They form one partnership firm. All the legal heirs, they formed one partnership firm, and they executed one power of attorney in favor of a person.
Well taken, but we are not discussing that.
Yes.
We are not discussing that. Kindly take to the first order the certificate proceeding.
Yes. Your lordship has
annexer either for the petition, counter, reject or anywhere is available.
LCR has come also. Your lordship order, they have also named the LCR.
Etc. scan.
Ashina. I got the lordship.
Not received.
Sir,
Actually, आपन का stand तो counter में सिर्फ stand रहेगा.
Counter रहेगा.
हाँ, counter देखना. अच्छा, next टा मुझे देखना.
unless your lordship go back the date of death and the formation of the partnership firm and the execution of power of attorney in favor of one of the legal heir.
Yeah, date शुरू. मैंने अपनो argue question as if they have initiated the certificate proceeding. You don't argue that. If you are saying that they initiated the certificate proceeding, then you have to be clear on that. That they initiated the certificate proceeding. It is you who has initiated the certificate proceeding.
Yes.
The certificate proceeding was initiated against whom? That is the discussion we are making, Mr. Mehta.
Yes. Then you,
रेडी है कैसे है
no, वो actually.
उधर रेडी है
I am having said. Your Lordship may kindly see the reply to our rejoinder. Annexure C/4.
to
Our rejoinder. Your Lordship got that?
Just look. IC 12/2018.
Yes, sir.
What is the first date of certificate proceeding? Say order from the state approval.
First date.
Which date away? Let us not. Let us be specific so that we will proceed fast. Order.
23/2018
Again?
23/2018
23/6/2018.
That is good.
Yes.
Application to application टा देखा.
Requisition टा recorded nahi. I will place your Lordship that order. 23/6.
position टाना
Problem is that and the mark and the provision certificate provision to that. Provision does.
Yes.
Because you have to be sure, sir. They have to apprise you as a counsel of the facts and the dates. So then you assure me that I am proceeding in the right direction.
Then in 23/6/2018, that has been mentioned.
Definition P does it. Definition P.
Section.
means a person name
Yes.
so definition of certificate debtor means a person named as debtor in a certificate filed under this act and includes any person whose name is substituted or added as debtor by the certificate officer.
Though I did not maybe that you may think that how could I use the exact language? Basic principle, first principle.
Yes.
The certificate act is very the Procedural Act is very specific and its nature of a recovery proceeding. So either the certificate debtor is filed or
Yes.
named as debtor in certificate.
Yes.
And includes any person whose name is substituted or added as debtor by the certificate officer. Now, if you are taking a risk being wrongly instructed,
Yes.
the partnership firm steps into the shoes of the certificate debtor. Because 2B itself says either substituted or added.
Yes.
Kindly look at page 15, annexure 12. Annexure 12 को देखो. तार declare अपना annexure you have filed C/1.
C/1. Counter. AB. CI1. CI4 one time.
Annexure 12 का file है sir rejoinder देखो.
Rejoinder.
हाँ 22 बार order देखो.
Yes.
देखो C कौन करते देखो. पढ़ो.
Lauren Advert for CTR. Oh.
कौन file है? Rejoinder बार करो.
Rejoinder C/4.
Page 15. Running page 15.
Rejoinder रे हमर running page का जोड़ा को. Rejoinder टा date
18.
No, 26 to 26.
26.
Sir, 15 page.
Page 15.
Page 15.
15.
15.
Yes.
Yes.
You have got it.
Yes.
Yes.
It is. It is.
No. ତା ପୂର୍ବରୁ ପଢନ୍ତୁ.
Certificate holder.
Certificate ମୁଁ ପଢି ଦଉଛି ଜଲ୍ଦି ହବ.
ଆଜ୍ଞା.
Don't mind me reading ହେଲା. The certificate holder DDM Choda also appeared and stated that HG Pandya and others is a partnership firm.
Yes.
And there are 10 partners in the firm.
Yes.
No reference to any substitution or any addition. Now kindly read then. Kindly read further. It is still interesting reading. Prime responsibility of all the partners to pay the certificate dues of the deceased debtor who have inherited the partnership.
Yes.
On facts, put handle say. When the deed was executed, who have executed, whether they are jointly or severally liable. Mr. Lenka, unless you want to favor some person, you will not pass these kind of orders. Well, you have blocked things from from sky.
Then after.
The officer is a responsible officer.
Yes.
He relies on the statement. Kindly mark first line. The DDM appeared and stated that H.G. Pandya. What is the basis? He has not looked into the partnership deed. He has not looked into the. If it is not registered, then another problem.
So in this case, partnership firm does not require any registration because there is no alienation of property there.
Let us not divert. Let us not sit the goalpost. Now, how the officer has proceeded? Just look at it. A statement is made.
Yes.
Mr. D.N. Lenka and family have become is a partnership firm, and he says that as if it is a pious obligation, Hindu law. Which provision responsibility of the partners? Which provision? Some semblance of respectability or substance should be there in the order or not?
So our
then one line, sir. Then one line. Then still one line. Hence, the certificate amount of rupees 92,66,21,483 is hereby confirmed. अपना government pleader नाहंती की city. Who is appearing for they should guide. Is it the amount? It is not the amount. I'm sorry, Mr. Lenka. It may be 1 rupee. It may be 100 crore or 1,000 crore. Mr. Lenka, if it is not a registered firm, you will have much difficulty. Right to sue and to be sued is not available under the Partnership Act. Business Association class. If you go to the first class, second point, if the certificate holder has stated that it is a partnership firm, on which day it was constituted, who was the after, because after death of a partner, if you examine Partnership Act, his legal heirs are not automatically substituted in a partnership firm.
Then partnership firm formed after his death, the death of the lessee.
You have got the point. If he was the certificate debtor and the partnership firm is formed after a deed of partnership, you are saying not registered.
And certificate debtor
after he has died. What is the date of death, Mr. Lenka?
7/2/91.
7/2/89?
Yes.
He passes away.
Yes.
Tell you listen. Mr. Palit, any dispute? 7/2/1989.
That's it.
Correct. So when the due is from?
Due is from 93-94 after common cause case.
Period, sir. Period. Common cause case कौन है कि common cause case रे pending dues टा collection करे बोले है ला.
हाँ सेत्रे विषय गोटे ये करचते ना 93-94 onwards.
ठीक अछि. 93-94 नो आपण कर ड्यू टा आपण जोटा लेखुचंती केबेठु अछि सेटा. को डेट रू ड्यू टा. से तो देना है आपण कहउचंती. I hope you understand. Somebody has not paid you. From which date it is due? That I want. Can you tell me that?
That is in the demand notice.
Attachment of payment.
So the point is, Mr. Oh, it requires lot of repairing. Mr. Lenka, because now kindly just you give me the date. You give me the date from when it is due. Now just kindly look at the mining lease, which forms the basis of your demand, and look at annex page 21.
But they read.
Yes, 21 because I don't have the running pages.
Yeah, 21.
Annex 1, page 21. Look at it.
Yes.
At your end, it requires lot of repairing.
95.
Yes, one. 21.
Kindly find out the partnership firm.
Mm-hmm. 21 is the mining lease, matter.
Correct. So that forms the basis of your
yes.
My understanding is
yes.
Because somehow, I mean, the order passed by the authority is so sketchy, one can hardly understand anything. Upon one line order, na certificate debtor appears, he states so and so is a partnership firm. It is the prime duty of the partnership firm to pay the amount and confirm. So regarding repairing, I don't think the police will object. Would you object the repairing on their part?
Whatever falls from your lordship, my lords.
So because when he stated, I was thinking that he may say that if I give a chance to you, then what you will do? And if I start recording now, Mr. Lenka, you must understand what I am going to do, what I can dictate. I have nothing in front of me to substantiate what has happened. I will decide maybe in favoring them or favoring you. But the basic recital of basic facts is not there.
A full opportunity before.
And for a lawyer of your stature, Mr. Lenka, I know, I have seen you. If the facts are with you, you can easily speak to the court.
He's devastating in any court with the files.
I mean, clarity of thought.
I was
when no material is before you, so obviously this struggle will be for. I mean, for me, it is a bigger struggle because once I was very young, late Justice P.K. Mohanty, I met him for a personal invitation. He said, "This you will realize." I didn't realize that. This side is almost because the lawyer has the liberty to throw a paper. Judge is duty bound to find out the facts, the dates, the reasons, everything. Same is almost for lawyer also, because you are not going to throw a paper.
In the lighter rain, my lords.
Yes.
For a period in my life, I felt little hurt for some issue. Now I feel that I have escaped.
No.
Now I feel I'm better off.
That feeling should be there with you and Mr. Lenka. He has crossed 70 now. I had a chance. Both Lenkas were appearing. I just in a lighter vein, many times I say these things. Senior Lenka, then I said, who is senior?
No, looking at that part, that side of your lordship.
So this, he has passed away, way back in 2001. There was no scope for me for thinking becoming. I was told that I should not think. ଆପଣ ବି ସେଟା ଫାଇଲ କରିଛନ୍ତି 22/12 ଅର୍ଡର ଆପଣ ଫାଇଲ କରିଛନ୍ତି
ଆଜ୍ଞା
ମାନେ ଆପଣଙ୍କର ଡକ୍ୟୁମେଣ୍ଟ
22/12
ଆପଣଙ୍କର ଯଦି ପେଜିନେସନ ନଥିବ
ହଁ, page-
page 15 again that result
page 6 page 6
Ultimately saying everybody is liable, so they are.
Mr. Lenga, if
what happened, my lord? You have
understood business association.
yes.
Business association is the broader perspective of kind of doing business. Business association first is partnership, proprietorship, partnership, and company law.
Yes.
Those they are governed by a statute. Partnership Act is governed by a statute. Certificate OPDR Act cannot override a partnership. So that much of basic exercise one has to do, so that you are able to recover it. Because it is almost direction midway. ଆପଣ ଗୋଟେ empty space ରେ you are losing direction. ଆପଣ ଆରମ୍ଭ କଲେ certificate holder କହିଲେ state it. What is there to state that? There has to be a certificate case, simple. You have to file a certificate case, he files it. Sitting. Or demand has to be there, but demand about ପାଉନାହାନ୍ତି ମତେ. I thought that demand is there.
Demand ଟା ବୋଧେ
Share ଆମେ counter ରେ ଦେଇନୁ demand. So your lordship before that your lordship kindly see annex D/4 7 page 7 next page. So what happened, my lord? When the demand was raised before the SD Pandya and others, that association of individual
But the problem is that when you are approximately the demand was raised, when it was raised, when the partnership came into being, when first of all when the amount became big, it actually paunas.
Sita silent. Sita silent. କିଛି ନାହିଁ. Sita totally silent.
Amount becomes due.
ତାପରେ
କୋଉଠି ଆପଣ ମତେ ଦିଅନ୍ତୁ
ନାଇଁ
ମାନେ ସିକ୍ୱେନ୍ସ ଆପଣ becomes due ହେଲା ତାପରେ
then
certificate is raised
notice was issued
ତାପରେ କେବେ demand ତାପରେ demand amount becomes due ତାପରେ demand କେବେ ହେଲା demand raised next date of ତାପରେ certificate issue ହେଲା
ଆଜ୍ଞା
ସେ ଆପଣ ମୁଭ କରିତେ ଆପଣ ତ କରିପାରିବେନି ସେଟା ସି ମାନେ ମାଇନିଂ ନ କରିକି ଯିବେ certificate ଅପସନ ତ certificate case initiate.
ତାପରେ
ଏଇ ଯୋଉ ଚାରିଟା incident ହେଲା what becomes demand raised, certificate case initiated, notice. So who is the debtor?
Debtor is SG Pandya and others. They clearly mentioned that an association of
ସେଇଟା ଟିକେ ଦେଖନ୍ତୁ
ସେଟା ଅଛି ଏ ଯୋଉ ପେଜ your lordship में see page 7 next page.
Page 7 in
Regender. Annex D/4.
reply to vision.
Yes. Reply to vision. Yes. Your lordship may see no first page. Know all men by these presents that we Jajanga iron and manganese mines, really known as Hargobind Pandya and others, having its so and so so so. Just I'm going. No, it's a power of pattern. Yes. So what happened after when demand was raised, by virtue of this power of attorney that is executed in 2012, so the power of attorney holder appeared before the collector through advocate.
No, sir, how does it help you?
Help.
ଗୋଟେ case initiate ହେଲା ପରେ ଜଣକୁ power of attorney ଦିଆହେଲା ସେ appear କଲେ So that
Power of party,
it's a demand.
all the partners.
Again, that order, power order, that doesn't refer to any power of attorney. That refers to partnership. Power of attorney is just like a vocalat now.
They
power of attorney, kind of power of attorney.
No, all the partners, my lord, your lordship, kindly.
You are very clear. After the proceeding is initiated,
Yes.
with Jahanar initiate calling, all of them, by executing a power of attorney, appeared. So what turns on that?
Appeared, and the power of attorney was authorized to act on behalf of all the principals, all the members. So
that is litigation before the collector, not regarding the mining lease or otherwise.
Only
this. Yes, because that invites more trouble for you.
Power of attorney doesn't.
If you relied on the power of attorney to initiate the proceeding, listen, is it your submission that you relied on the power of attorney to initiate the proceeding?
No.
That is there, sir.
No,
Power of attorney.
But the petitioner's case, my lord, petitioner's case is that the power of attorney, Devendra Pandya, who is the power of attorney holder, he has appeared for himself.
That you can appear. X can appear, Y can appear, because appearing before a authority in a
Yes.
is like a vokalatnama.
Yes.
So that and your power of attorney, that order is completely different, and that this power of attorney is much after.
Not much. This is 2012, my lord.
Okay. So, but
Demand was read. Demand was
given by certain persons.
all the persons.
Every person.
Yes.
Everyone.
That so is our power of attorney.
Can that form the basis of your demand? So your demand is very clear, mister. You look at that power of attorney order.
By sir.
By
Yes. The lawyer and advocate for the CDR. This power of attorney holder engage the advocate.
Sir, that is regarding the demand, sir. ଆପଣଙ୍କର ଯୋଉ 22 ବାର ଅଠର ସେ ଯୋଉ ପ୍ରୋସିଡିଂ ଫାଇଲଟା ଦେଖାନ୍ତୁ
ଏଇଟା ଏଇ ଅର୍ଡର
ହଁ 22 ବାର
ତା ପୂର୍ବରୁ କୋଉଠି ଆରମ୍ଭ ହେଇଛି କାହିଁକିନା ସାର୍ଟିଫିକେଟ ହୋଲ୍ଡର ଯୋଉ ଜିନିଷଟା stated that କହିଲେ
yes
ସେ କାହା ନାଁରେ ସାର୍ଟିଫିକେଟ ରେଜ କରିଛନ୍ତି କିଛି କହିଲେନି ତାପରେ ଇଏ କହିବା କଥା it is prime responsibility
yes
କିଛି ଲକ୍ ବି ରେଫର କରୁନାହାନ୍ତି sir ଆପଣ ଯଦି ସାର୍ଟିଫିକେଟ ହୋଲ୍ଡର କୁ ପଇସା ଗେଟର କୁ ପଇସା ମାଗୁଛନ୍ତି ପ୍ରାଇମ ରେସ୍ପନ୍ସିବିଲିଟି କଣ what is the prime responsibility I don't understand
prime responsibility
the so and so is the certificate debtor and accordingly the file so cost or reply not paid the certificate dues hence the certificate is confirmed one line
the first your lordship may
partners to pay the certificate dues of the deceased debtor. If the partnership firm is the debtor, upon the partnership firm against ही करिवे. तो सेति पई से फास्ट ऑर्डर ता आपण देखिबा दरकार. ना आपण बुझी परिबे 22 बार ऑर्डर कोन हैला आपण बुझी परिबे unless if assuming that 22 बार ऑर्डर पूर्व किछ ऑर्डर नाही. Then it is
then अच्छी ना
then it is still was.
It 23/6/2018
This short.
again नहीं रेकॉर्ड हाईकोर्ट को ଦେଇଛନ୍ତି ନା ହାଇକୋର୍ଟ ଆଣିକି ଲାଷ୍ଟ ୱିକ୍ ରେ ଦେଇଛନ୍ତି ମତେ
ଏଇ 6 ରେ କଥା ଅଛି
सर्टिफिकेट केस कितने कहले
सर्टिफिकेट केस
35
30
कितने
30/2018
ଆଜ୍ଞା
35
ଅଫିସର ଦେଖୁନ ଲେଖୁଛନ୍ତି କଣ କେସ୍ ନମ୍ବର ଲେଖୁଛନ୍ତି 6/2018 your lordship may kindly see if your lordship have the order
23/18 को पेज रे अछि
petition
माने आपण petition को रेफर करबै
read petition
माने read counter result
read
ଅଛି 23/6 ଗୋଟେ ଅର୍ଡର ଅଛି ଫର୍ଷ୍ଟ
Mr. Linka, problem is again, please answer, please consider this aspect also. You have to answer this also.
Aye.
Your basis is Annexure 1, or you are disputing that. Annexure 1 is not the basis.
Annexure 1,
lease deed.
lease deed.
Annexure 1, where it mentions regarding the partnership power.
Your Lordship may kindly say second para, page 21. I am reading.
21.
21. Annexure 1 now.
Yes.
Sri Kanta Prasad H. Pandya, son of Sri Hiraj Dhanji Pandya.
ନାଇଁ ସେଇଟା ଆପଣ ନାଁ ଗୁଡାକ କହୁଛନ୍ତି ଆପଣ ଟିକେ ମୁଁ ସେଟା ପଢିଛି ବୋଲି ଆପଣଙ୍କୁ ପଚାରୁଛି ପେଜ 22 କୁ ଯାଆନ୍ତୁ
Next,
ସବୁ ଜାଗା ନାଁ କହିଗଲେ
which expression
ନାଇଁ ନାଇଁ
in the middle?
ନାଇଁ ନାଇଁ 9 ପରେ ରଶ୍ମି ପାଣ୍ଡ୍ୟା 10 ତାପରେ ଦେଖନ୍ତୁ
9 ପରେ 10 ଗଲା।
ହଁ ପାଇଲେ 22 ଛୋଟ ଅକ୍ଷରରେ ଲେଖା ହେଇଛି
Kumari Payal Pandya, daughter of late Hargobind Pandya, aged about so and so, Jamshedpur, the Indian state of Odisha, occupation mining business, herein after referred to as the lessee.
ସେଇଠି ଦେଖନ୍ତୁ ସେଇଠି ସେମାନେ they are not entered into a partnership ଲେଖା ହିଁ ହେଇନି
ଇଣ୍ଡିଭିଜୁଆଲ ଲେସିସ୍ କରିକି ସକ୍ସିଡ୍ କରିଛି
ପ୍ରୋବ୍ଲେମ ହେଇଛି ସେଠି
ସକ୍ସେସର୍ସ ବୋଲି ଲେଖିଛନ୍ତି
For you, I was thinking. In fact, I was thinking in those lines that maybe there is a partnership firm which has succeeded.
No, it has not succeeded.
Then your ultimate second.
So now kindly mark. No, please don't leave it. That is very important.
Yes. Your ultimate
22 days separate dekho. Whereas kindly mark kale kon what?
Whereas the lessees
have applied. There is no mention of partnership firm.
ता पूर्वटा टिके पढ़िबे ता पूर्व dependent last line Badville and PS Badville district Keonjhar in the state of Orissa, the power of attorney holder of Messrs Hargobind Pandya and others.
Correct. They apply kale lessees
ने जणे execute करछि जणे
ना कांता पर से ये execute कले is not important आपनकर document कोन कहूची they are the lessees तापरे आपण देखंतु insert second paragraph जोते आपण एबे देखौतिनी
whereas the lessees have applied for the state government in accordance with the mineral concession rules herein after referred to as schedule mining lease iron ore and
State does not recognize the farm. State recognizes the lessees individual. That is
and likely Mr. Mr. Lenka on the fight it should not have stated like that by the deputy director minds. He was under a lot of pressure. He should have simply kept the matter straight. Looking at the lessees, looking at the lease deed, he should have maintained that before the certificate officer. I don't know who has brought in this partnership concept and where it has been brought in this certificate proceeding. 12 is because 12 doesn't refer. Sorry, I'm so sorry. Again, that 12. 18 को 12 बारंबार कर दूंगी. 18-12 straight away speaks at the statement of the deputy director. Deputy director has not looked into anything. Unfortunately, the certificate officer simply one line says they have the pious duty upon. They have the greatest responsibility. The prime responsibility. Prime responsibility, if it is borrowed from UPDR Act or Partnership Act, would be nothing is there.
But
kindly just take. Then again, then look at the list deed again. 20 up to 23, do not find any reference to any partnership. Now, Mr. Lenka, if I'm going to record that,
yes,
then you are not even saying to that extent. But that the power of attorney holder was of the partnership. Unwittingly, what has happened? The power of attorney you are relying on is not for the partnership.
Yes.
It is not at all.
No, not that is there. But
That's the problem.
But your lordship on 23/6/2018 order, that is clearly mentioned.
Court se page ta ke कहले
23/6/2018 रेकर्ड टा मो पाखे जो रेकर्ड अच्छी से खाली पढ़ी दूची हाईकोर्ट रेकर्ड आसी जाइए बोलते आसी नहीं the Peru the certificate requisition on 23
slowly पढ़िबे
slowly
slowly पढ़ो
on 23/6/2018 Peru the certificate requisition received from Deputy Director of Mines Joda by this letter number so dated 24/5/2018 wherein he has submitted this requisition under section 6 OPDR Act 1962 to initiate certificate case against HG Pandya and others so for service 92 crores 66 lakhs so only towards compensation under section 21(5) NDR Act 1957. So your lordship see what I am trying to say, my lord. Here the requisition submitted by the Deputy Director in the against the SG Pandya and others.
It cannot be by implication, sir.
Others means all the legal heirs.
It has to be partnership firm. If you are saying partnership firm, again come back to 22/18 order.
22/18.
23/6/18 नहीं जानतु नहीं उल्टान्तु नहीं सर.
Yes.
If that is so on 23/6/18 then 22/18 should not have been passed.
No,
22/18 gives that the partnership firm is the legal heir, they are the prime responsible. Legal heir what be hujeni? They say, the officer says they have the prime responsibility to pay the dues. Nothing more, nothing less. So either you stand by 23/6 or by 22/12, it is incongruous. Because then now you are saying, Mr. Lenka, yourself, 23/6 the partnership firm was not in the picture. Then read further. Then read further that order. I read it somewhere. I don't know. Say order 23/6 outre padho.
Under section compensation under section 21(5) of MMDR Act 1957 towards production of mines without environmental clearance, production of excess mine without adequate environmental clearance, along with the interest of
allegation, sir. Allegation.
In the final outcome, register a case under section 6 of the issue notice to the CDR in form 3. Notice of certificate data.
So where he has you are so now have you seen that what was the order passed by the certificate holder? I mean, who has approached the authority? Has he passed any order also? He doesn't refer anything.
Thereafter, the notice.
Like the problem is now in the certificate case, DDM says that X is the certificate debtor. The authority says issue notice to certificate debtor. After some time, the authority says has recorded. DDM has visited me. He says, and 18/12 language ta dekhon. That DDM order no. 22/12.
It is the prime responsibility of all the partners. Law and advocate.
The certificate holder, DDM Joda, appeared and stated that he should have filed some document, some HG Pandya and is a partnership firm. If you start with Annexure 1, no mention of any partnership firm.
Only name has been mentioned.
Nothing, sir.
Only HG Pandya and others.
No. Lessees. Then you have missed it, sir.
Annexure 1 lessees.
Annexure 1, no. Annexure 1 is very clear.
Lessees.
17 ଜଣ ଲୋକଙ୍କ ସାଙ୍ଗରେ ଆପଣ ମାଇନିଂ ଲିଜ୍ ଦେଇଛନ୍ତି 17ଟା ଲୋକଙ୍କୁ ଆପଣ 17 ଜଣ ଲୋକଙ୍କୁ
ତାଙ୍କର ସବୁ ଗୋଟିଏ ପରିବାର
ହୁଅନ୍ତୁ ସେଟା ତ
there is a mention of lessees. No partnership.
No, sir. I mean, so that is the now suppose The deputy director minds was in a hurry or some reasons or God only knows what was his purpose. Why he did this before the certificate officer.
Lordship, can I just sit down for
You must. Don't stretch yourself. Mr. Lenka, whenever you feel like sitting, please sit.
Yes, sir. ଗୋଟେ ଡକୁମେଣ୍ଟ ମତେ ଦେଇଛନ୍ତି ଗୋଟେ ପାର୍ଟନରସିପ ଫାର୍ମ that was executed in 2000 first day of April 2003 but I have not annexed এই question ଟା ପଚାରଲା
ଆପଣ ଭଲ କରିଛନ୍ତି କାହିଁକି ନା they are what they are doing I don't know a lease is stated 3/2/95 there are 17 ଜଣ ଲେସି ଅଛନ୍ତି
95 ଏତେ ନଥିଲେ
ମୁଁ କହୁଛି 17 ବର୍ଷଟାକୁ 17 କହିଦେବି there are even a minor ମାନେ ବି ତାଥିରେ ଅଛନ୍ତି ଆଜ୍ଞା 10 ଜଣ ଲେସି ଅଛନ୍ତି 10 ଜଣ ଲେସି suppose thereafter they form a partnership firm without the lease deed being amended in any manner it will never devolve on them
ये जो तापर कौन है
तापर आपनकर
सब्सिक्वेंटली रिन्यूअल है यही चाहिए
आपनकर रिन्यूअल ले भी देखंतु पूरे पार्टनरशिप फार्म अछि की
रिन्यूअल है यही
देखंतु स्टेट आपण लीज दे जदी रिन्यू करछंती पार्टनरशिप फार्म मु सेति पे आपनकर डिमांड डेट ता सेति पे पचारथिल
आज्ञा
सही कॉन्टेक्स्ट ही पचारथिल
तापर 3-4 थर ये ହେଇଛି रिन्यूअल ହେଇଯାଇଛି ସେଇପାଇଁ ଗୋଟେ ଡେଟ୍ ଚାର୍ଟ କରିଥିଲି
Mr. Lenka, kindly mark again. You have to go to the basic document, page 22.
22
of the writ petition, which is date chart ta diyantu. Date chart ta dela hoje jo date uda nahi ta add kari habo. But problem है how to proceed with the hearing without these basic facts. अपन author 22 de sir देखो अपन जोड़ा renewal कथा कहउचंती you will find it there 22 देखो
आज्ञा
kindly mark the subpara recital सरी वाला recital पाइले सिंह बूम पाइ गले
हां
11 वर्ष about 11 years IL Pandya, is it about 11 years?
Yes.
Mining business?
Yes, sir.
Expressions shall where the context to admits be deemed to include their respective heirs, executive administrators, representatives. They are permitted assigns of the other part, represented by Sri Kanta Prasad H. Pandya, son of Hirji Dhanji Pandya, so and so. Mining citizen, dekhantu, lessees. Expression da hochi the
lessees.
Hereinafter referred to as the lessees.
Yes.
Middle of that para. Then just read the subpara. Whereas
lessees have applied.
Yes.
To the state and
lessees have applied.
Yes. Applied to the state.
Have applied.
Yes.
And you have granted the lease to them.
Application was by the lessees.
Lessees.
Not the partnership firm. And government has renewed it.
It is
in the name of the lessees.
It is executed in the year 1995.
Fair enough. Part of the demand goes in the 95 demand.
93-92.
ଆପଣ sir जो lease देले आपनको demand sir कौन बुझिଛନ୍ତି कि
आज्ञा
ଆପଣ lease ଦେଇଛନ୍ତି environmental clearance नथाय कि से केते जगह रे खोलिଛନ୍ତି
illegal mining and environmental data
whatever So Satan, it is not a case of mining without lease. Mining without lease कोड़ा जानते तो? ये जगह
Yes.
Mining without lease
It is outside their area.
Sale against allegation, mining corporation against allegation.
Straight.
बहुत जणो सेटा केमिति हिची मु कहि परिबिनी सेटा ଗୋଟେ ଅଲଗା ଜିନିଷ।
এই जो 395 जोटा annexure 1,
yes,
your lordship will find that this is a second renewal application for lease of for a period of 20 years from 93 to 30.
Supreme Court कहले जे थर्ड रिन्यूअल परे हबनी किंतु as a matter of fact Mr. लेंका
yes
समस्ते भारत वर्ष रे समस्ते करिथिले थर्ड रिन्यूअल till Supreme Court decided in Goa Foundation that automatic renewal and automatic renewal of the ye hei paribo. That we are not discussing.
Yes.
Let us not go there because that will I mean divert our attention also and dilute our concentration.
So 395 रे execution कले agreement ए जो contract तापरे 1/4
lease आपण lease देले sir.
हां lease 1/4/2003 then just one month after
तापरे गला देखंतु पर पेज 27 को जा
madam
File 27
yes
internal page 7 पढ़ो सर बाउंड्री सरला तापर कोन लेखा thus the traverse
closes covering an area over 247.44 acre
to 47.44 acres
44 acres or
100.137
hectares
land schedule of the renewal mining lease area सेटा आपण ताकर लेसिस को नारे भी करछथि रिन्यूअल
land schedule of the renewal mining lease area of Messrs.
So if you take the word renewal mining lease area is serious, then this is a renewal in favor of the lessees 1 to 11.
ना सेठी भी लिखा है आगोटे कथा भी लिखा है सेठी
पढ़ो
land schedule of the renewal mining lease area of Messrs. H.D. Pandya and others over 247.44 acres or so and so.
सेठी भी आपणकर लिखा है पार्टनरशिप सर
That's what my lords was pointing out. Lekha in partnership. Not because the link.
The reason being
Substitution is the lessees have been substituted.
The reason being they applied and they got it in their name. And you had neither they formed a partnership by that date, even if they formed a partnership, or some of them formed a partnership, which I was trying to tell you also. Let us assume they have formed a partnership. That has nothing to do with the mining business because it's a statutory lease.
No.
That is the problem.
Your lordship will.
I don't know why the DDM thought appropriate to tell the certificate officer there is a partnership firm. She should call a prime responsibility. These are the two words.
No, after this agreement,
openings. Now, after this agreement, have they entered in state? State the lessee who is demanding, who has given the lease.
Recognized CORAM state. That's what my lord is indicating.
Where is the state, sir? Where are you? Where is Mr. Lenka?
Owner is not recognizing. What's falling from my lords is that.
The top are
kindly mark then, sir. Kindly just again go to 32, sir. Part 2 of the lease deed. Actually, this is a statutory format.
Yes.
Kindly mark.
Part 2.
Yes.
Liberty and power at all times during the...
No, sir. Heading, sir. Heading is important.
Heading. Liberty...
Enjoyed by the lessees.
Yeah.
No mention.
Page 32 to?
32 रे lessees लिखा है. No partnership, sir.
Page 74 is clear. Page 74.
32 देखो मुझे.
32.
Lessees, by the lessees.
सी कौन करी पारी
subject to the restriction and conditions.
Mr. Lekha, what they can do?
Yes.
What they can do, if that continues. Mr. Lekha, have you not marked in tax matters?
Yes.
You for some time you were in the standing council for the tax.
No.
Okay, you mark in tax matters. They will immediately stand up and say that let it be remanded. Some benches did not do that. I have seen my justice conscious. You will never remand because many times you will find while typing the order they have mentioned some other assessing, other year. If you interact with them, the officers, they will come to you running. Mr. Lekha is the standing counsel. They will say, "Sir, this is a blunder. I did not realize it was a lot of pressure on me." So I asked that I simply
Never allowed correction. Never allowed correction.
No, I have in short.
So that is how they resurrect the case. But I suggest they will not. They know that they realize that by remanding it, the tax authority will again repair everything. Because if you tell the High Court that actually more,
I was a little hesitant when your lordship said whether I'll oppose or not to the repairing.
नहीं केते रिपेयर हे परबो आगे इरिपेरेबल जदी आ कोन करा दियो
ना पेज 74 टिका हाउ इट इज
नहीं मु सेटा इनफैक्ट से पूराटा देखि दियो लेट मी मिस्टर लेंका भी गो थ्रू द एंटायर ये नाउ तो सेटा तांकर चलला नाउ जस्ट पार्ट 4 को जानतु पार्ट 4 हैला पेज 38 Mr. Palit, it is like this. As a lawyer, when you have done your part, see repair koribe ne tanko choice. I am not going to that area. Mr. Lekha will not be bothered whether they are repairing or not. Part 4, liberties, powers and privileges reserved to the state government.
Yes.
So that is how you find the lessees and the state government.
The question.
The principals are joint lessees for the mining.
I will be achi. Page 40 re bhi achi lessee.
40 re achi lessee. Point following from your lordship is fundamental. Actually, they don't. That goes to the root of the matter in a long way.
Foundational facts. As it called, foundational facts should be clear.
Repairing would be impossible at this stage. Almost. Difficult to.
Sir, again, Mr. Lekha, paste internal page 20 of that lease, running page 40 of the brief. The lessees shall pay for every year except the first year the lease deed rent as specified. Kindly mark if you say this is due. You may say this has not been paid. I don't know. Maybe that is your case. To pay dead rent of royalty, whichever is higher.
Similar paid.
That is the due.
What that paid?
Could you get it, sir, Mr. Lekha?
Yeah. Page 74.
No. Mr. Palit is referring to something. Apno 40 rahi roll.
My lord is referring to 40. Yes. Stay on page 40.
Page 40, internal page 20.
Page 40.
ଆପଣ ବାପଟ ମାର୍ଜିନ ଟା ଦେଖନ୍ତୁ କଣ ଡ୍ୟୁ ରହିବ ମାନେ dues to be payable to pay dead rent of or royalty whichever is higher.
Yes.
Then rate and mode of payment of dead rent. You just mark the right hand now. The lessees shall pay
for every year except the first year of the lease dead rent as specified in clause 2 of this part. Provided where the holder of such mining lease becomes liable under section 9 of the Act to pay royalty for any mineral removed or consumed by him or by his agents.
Manager, employee, contractor, sublessee, this area, he shall be liable to pay either such royalty or dead rent in respect of the area, whichever is higher. So the same thing, he has to pay the higher part.
Yes.
Rate and mode of payment?
Subject to the provisions of clause 1, clause 1 of this part, during the subsistence of this lease period, they shall pay to the state.
Then kindly, sir, then, seta actually just reiterate hochi, please just, skip over. Para 3 jai padantu. Rate and mode of payment of royalty. Then just kindly again read payment of surface rate and water rate.
Wow.
The lessee shall pay.
The lessee shall pay rent.
So again the lessee. Now though, if you raise a demand against a person who is not a lessee or a non-lessee or other than a lessee or against a company or against a business association, I make it broad. Business association of the lessees, then what would be the consequence? Business association 2 types, partnership, company, limited liability or liability, whatever.
It is admitted that after this agreement, they formed the partnership.
That's the problem. That's
one
the
more
problem.
chapter.
That's the problem.
And authorized.
Rather it was in your interest not to lose track of the lease deed. Pursue the lease deed. Please appreciate this. All of us present here, 7 persons are lessees, 10 persons are lessees, 3, 6, 8% lessees. Lessee, whatever they are, you have seen the government dues they have to pay. You have to say that you have to pay this much. But somehow, thereafter, after the lease has been executed, we have entered into a partnership firm, all 8 of us. Registered. So registered means there is right to sue and to be sued. Or unregistered. Then we are doing some business, maybe dealing with that. Then my understanding is that in the best interest of the principal, government, they should have stuck to the lessees. Okay, because your first paragraph itself is very clear. Unless the context otherwise requires, it shall include so and so, and the assigns. But somehow, by this order, 22/12/2018,
and government also recognized the firm. Because your Lordship will see, I am just reading, on 14/7/2010, agreement was executed in 2003. On 14/7/2010, 4,61 lakhs 43,000 were deposited by the firm, partnership firm, towards conversion cost of forest land. That is also there.
What can be done, sir? That again goes against you.
Agent can deposit.
You are raising a demand of land royalty. I have showed you what are the rate and mode of payment of royalty.
Yes.
Rate and mode of dead rent or royalty, whichever is higher, and other things against the lessee. Now, suppose let us assume what you are saying has a bearing, because that's not disputed. No one is. They are not disputing that the partnership firm has deposited the money, but the money is demanded against whom? The lessee.
Yes.
Somebody, a banker, suppose pay. They take a loan and pay the amount. So it has to be the lessee. That is how the section is very clear. Certificate debtor means the person named as debtor in the certificate file under this act and includes any person whose name is substituted or added. If you now, unfortunately or fortunately for them, the authority by order dated 22/12/2018 does not refer to any kind of substitution or addition. Has he? Or if it is not there in 22/12/2018 order, has he passed that any kind of order in any other date? Whatever brief I have understood. I mean, it is too many facts, but I don't think there is any order satisfying to be substitution or this addition.
Your Lordship may call some other day.
So that is how that is text. He must also count the basics of getting the chance before the authority. Because now, if I delve into these facts, and
I was talking with the Tahsildar concerned.
Mr. Lenka, the problem is that the best of the authorities, they don't understand the basic past principles of law.
both deputy
लीगल ट्रेनिंग तो नहीं आपण जदी ताको एक्सपेक्ट करिवे जे सेमाने ए जिंसटा को ऑर्डर रे लेखिबेनी यू हैव सीन द ईएसआई अथॉरिटी सबुथरे ऑर्डर रे से लेखुचंदी सबु जगह रीट फाइल होची नोटिसेस वर इश्यूड टू सो ऑर्डर पास्ट notices were issued when तापर तो लेखिबे इट वाज सर्वड ऑन सच एंड सच डेट स्टाफ रिपोर्ट हैज बीन कंसिडर्ड सर्विस रिटर्न हैज बीन रिसीव्ड अच्छा if they would have simply stopped to the certificate proceeding भलो होइथांता simply टू बी रे ऑर्डर पास करथांते टू बी ऑर्डर पास करथिले सब्स्टिट्यूशन करिथांते कि नोटिस देथांते जाइथांता किछि तो ऑर्डर ही नाही Now the problem is if you go to the basis of the demand is the lease deed. The lessee प्रथम कथा हला जे 11 जण lessees shall pay. Lessees have these duties. Now the state has right to recovery from the lessees again. Now I will go to your page. आपण को पेज को नोचन
नहीं ता पिक्चर के मु देखि सरले नीचे आउरी अछि lessees चारियड
That's the year.
lessees तापर 74 रे पुनी अछि the principals are joint lessees 74 second whereas the principals are the joint lessees in respect to the mining.
So that is a clarification you are saying. What page is it?
7
Page 74
of the lease of the REIT. तापर 40
और internal page what 80 मतलब
46 रे भी अछि page 46 रे the lessees shall make and
sir
Your
Hey,
lordship.
sir, kindly just look at another interesting part, sir. Page 70, sir.
70?
Sir, 70.
70.
Notices भी sir define कर देचंदा आपण.
Notices.
every notice shall be given lessees.
Be given in writing to such person resident on the said lands as the lessees may appoint for the purpose of receiving notices. When notice is defined, sir, because this is classical, this is old classical documents.
पूर्ण document আছে ওটা
Right? के 71 को गले 71 टा नोटिस टा इंटरेस्टिंग लैंग्वेज लिखा है देखो पूराटा पढ़ी जाऊ सेंटेंस माने लंबा सेंटेंस.
every such notice shall be sent to the lessees the registered post addressed to the lessees at the address recorded in their lease or at such other addresses in
Address
India.
recorded in the
lease
first paragraph. So it means I was
Or
thinking
as
some
such
of the
other
kind
addresses.
individual died.
In India, as the lessees may from time to time in writing to the state government designate or receipt of notice and every such service shall be deemed to be proper and valid service upon the lessees and shall not be questioned or challenged by them.
Annexure to the restriction, my lord, that is the partnership arm. They have annexed. In the page 73, what kata lekha hai?
Mr. Lenka, may I say this? Audio ta bond kar. This was placed before the Honorable Supreme Court. The Supreme Court has been given the impression that because of the pendency of the High Court, the matters are not proceeding.
That was sad.
Actually, it is not that.
That was sad.
Actually, it is not that.
I was filed.
Actually, it is not that.
That
It is not because of the pendency of before the High Court. Because High Court has no way come into the picture because it is the and
It is as
everyone
if
has
the
a right
High
to
Court
approach
is-
the High Court.
It is as if the High Court is not hearing deliberately or some.
Not that. So that also is a matter of concern. So now suppose the High Court now decides to hear it. Today, the way we have proceeded, I think we have at least touched the basic fundamental issues to be answered before this court. Because it is the liability is being challenged. So we achieve actual churning jetiki helani. The way we have churned the facts, I don't think we have the answers to the basic fundamental questions. When the amount becomes due, when the demand was raised,
Taken note.
when the certificate case was initiated, when the notices were issued, and amounts become due, what is the basis that I have been asking? Because I have, whatever assistance I have got from you, is that my reading is that Annexure 1 is the basis. because it itself specifies the rights and liabilities of the lessor as well as the lessee. The lessee will pay these things. And they have been paying, as it seems, they paid for the period where second renewal. There is no automatic third renewal. But everyone carried with the impression, like the first renewal, second renewal, third renewal also automatic.
Would be automatic.
They went on. That the Honorable Apex Court said, bad in law, conceptually not possible, Goa Foundation, then subsequent interpretation. And then the Supreme Court has approached Honorable Justice Lokur, as then he was, he did not accept the contention that since everyone was continuing with the impression that it will be renewed. It was rejected. So in that scenario also, whether High Court is anywhere responsible?
No, 26A is there in that. The impression, if at all, was given, deeming provision was there. It came by way of an amendment. Earlier there was no amendment. So they said that we are facing huge loss, investment and all that mining industry. So unless you give us then to obviate that difficulty of the lessees on the teeth of heavy investments, the legislature thought it fit to introduce a deeming clause, 26A. So by virtue of the deeming clause, and the lease deed renewals were taking for years. So therefore, they said, no, you continue, we will not penalize you for that.
But with certain conditions.
No, conditions, you are bound by the lease deed, height bound by the lease deed.
But here in this case, so much.
It was decided that.
The matter is taken up. It has WPC 31548 of 2025. The matter is taken up as being listed in the special bench assigned to take up the matter for hearing. The hearing continued for 1.5 hours. The learned counsel for the petitioner was heard at some length. The learned additional government advocate appearing for the opposite party state was also heard extensively. For further paucity of time intervenes for further hearing of the matter. List on. So you think you take it seriously? So because again, just audio type
trouble you lordship 11 तारीख को 3टा बेले 11
ମାନେ 3ଟା ବେଳେ ହେଇ ଯାଉଛି କାରଣ ସେ ମୋର ନୋଟିଂ ବାହାର କରି ଦଉଛନ୍ତି actually mark that yes
so ମୋର actually ଗୋଟେ ସେଟା ପାଠା ରହିଗଲା ତ
କିଛି ଅସୁବିଧା ନାହିଁ
sir
2 PM ରହିଲେ ଅସୁବିଧା ନାହିଁ because this is the same bench.
No, I would.
But this thing, I mean, we instructed by the Chief Justice that the other bench will continue after this bench notice. But I cannot ask the lawyers to wait.
Because my difficulty is court closing. I'll be leaving on 14th. So last moment, a lot of matters are there which would have attend kore put
sufficient. Sufficient.
ମାନେ ଟିକେ ଡେରିରେ କରନ୍ତୁ 12ରେ କରନ୍ତୁ
ଆଉ ଡେରି ମାନେ
12ରେ କରନ୍ତୁ
11ରେ ରଖନ୍ତୁ Mr. Linka should have the time to discuss and ponder over this.
ଆଜ୍ଞା ଠିକ ଅଛି
pondering I don't require, he doesn't require, but he requires to discuss.
No, he is very
so that way he understands this.
He is great. Interim orders will continue.
Interim order as past subjects will continue till the next day. So Sudhir Pali, senior advocate, along with Ms. Arunima Pradhan for the Mr. DN. Yes, please. Second matter in the connected deed petition 31548 of 2025 was heard extensively. As the learned counsel for the senior advocate for the petitioner and the learned AG were heard. Paucity of time intervened and the said petition has been adjourned to Vigara. It's a Vigara of upon this Occident. ଯେତେବେଳେ ଆସିବେ ସେତେବେଳେ ରିସିଭ୍ କଲେ ଆରମ୍ଭ shall be listed in the special list. So shall be ଆପଣ ଏଟା କଣ ଲେଖୁଛୁ ସ୍ପେସିଫିକ କହିଲା କାରଣ ଯେହେତୁ ଚିଫ୍ କୋର ଅଛି ଅର୍ଡର ସେ ମାର୍କ ଆଟ୍ ବୁକିଏ ଟିମ୍ ରେ ବି ସେ ଅର୍ଡର
May I pardon to mention, my lord? My lord, item 35 in the first list. My lord, can it be taken up any day before vacation?
They have already date given.
Okay.
Sir, what basically actually now by adjourning and some dates we are readjusting. 1 तारीख 2 तारीख ହେଲା ମଝିରେ ଗୋଟେ 13 ତାରିଖ ହେଲା so now what we have done now we have reached a stage 4-5 week ରେ we have crossed 100 11-5 ରେ we have crossed around 110 18-5 now 18-5 18-5 is only left he had 50 today he will go on adding to that because judicially adjourned matters have to be taken up have to be listed to that the fresh matters and other matters memos are added. So that is the difficulty now. ଆପଣ ଆସିଲେ କିନ୍ତୁ ସେଇ ଲମ୍ବା ହେଇଯିବ ପଡ଼ିଗଲା ନା ପଡ଼ିବ ଯେକୌଣସି ଗୋଟେ ଡେଟ୍ ଦିଅ
18/5
Any other matter, any learned counsel present in the first list, Mr. Rajendra?
Madam, my lord, this is a matter under section 125.
I give to police. Going to the first list, item
Item number 13, my lord.
No, serially sir जो पड़ी और मने ने को दे
Sorry, Sahoo, sorry.
Item.
Mention.
कौन बोलते सर कौन तू?
My lord, this is a order against family court of the Bhanipatna court, and I have come against that order because it is on the higher side. My lord, it was 50,000 has been awarded by the family court under section 125.
Mr. Board?
Yes, my lord.
Can you please hear me? Sorry.
Yes, my lord.
More on nothing. In these kind of matters, the law is very clear.
Yes, I am not denying, my lord.
So you have to file affidavit how much amount you are paying or depositing.
I am bearing all the expenses of petition number 2, my lord.
That is not the question, sir. That is not the question. You are challenging a judgment and decree of a court, family court.
Yes, my lord.
Family court has directed, as you have said, 50,000.
Yes. That is
out of the 50,000, how much you will pay as per your instruction and what is the area?
Area is 10 lakh, my lord.
Correct. So how much you will deposit in the trial court?
I've already paid the amount of 5 lakh towards the expenses of the petitioner number 2 that I filed in the lower court.
Sir, don't go by the perception of your client. You are the lawyer.
Okay, my lord.
Sir, you find out what is the amount payable and how much you have paid. If you have paid, that's a different thing.
Okay, my lord.
ଆପଣ କୋଉଠି ଖର୍ଚ୍ଚ କରୁଛନ୍ତି କଣ କରୁନାହାନ୍ତି କାହାକୁ ପାଟ ଶାଢୀ ଦଉଛନ୍ତି କାହାକୁ ସୁନା ଗହଣା ଦଉଛନ୍ତି କାହା ପାଇଁ ଘର କିଣି ଦେଇଛନ୍ତି those things cannot be considered by the High Court. High Court in revision cannot consider those things.
No,
simply it is not an appeal even. Revision, the High Court cannot take a view because it feels to be different view.
No,
if your client files affidavit stating how much he has paid towards satisfaction of the order of the trial court, you do that. Then you place the matter. Otherwise, after arguing half an hour, the order will be passed. The petitioner, the learned counsel shall obtain instruction. No point. That is how I am spending time. Already we are over since 1:15 p.m. But you must know what you are, how you are before, where you stand before the court.
My lord, ମୁଁ payment କରିଛି my lord. କିନ୍ତୁ କଥା ହଉଛି ସେ
payment ତ ମତେ କରିନାହାନ୍ତି ନା my lord କୁ କରିନାହାନ୍ତି କି ଆପଣଙ୍କୁ କରିନାହାନ୍ତି ଆପଣ affidavit ଦେବେ.
Yes, my lord. That's why I am saying that because I have already paid about.
କୋଉଠି affidavit ଦେଇଛନ୍ତି କି?
I'll file it, my lord. But
ତ କହୁଛି ଆପଣଙ୍କୁ ଆଜ୍ଞା.
In the meantime, my lord,
I don't disbelieve you or believe the other person. That's not the point. The point is that what is on record.
Exactly, my lord.
Yes,
my lord. I will give an affidavit on that, but as district warrant has
affidavit don't write essay on payment. Make it very specific. Who date re order hela? Apano ko dino dele, kouthi dele. That's it. Mode of payment, amount of paid, date of order kebe hela. ଆପଣ କହିବେ ଯେ ଆଜ୍ଞା ମୁଁ ଯାଇଥିଲି ତାଙ୍କୁ ବୁଲେଇ ନେଇଥିଲି ସେଥିରେ 10 ଲକ୍ଷ ଟଙ୍କା ଖର୍ଚ୍ଚ ହେଲା ସୋ 10 ଲକ୍ଷ ଟଙ୍କା ସାଟିସ୍ଫାଏଡ ସେମିତି ସେମାନେ ମୋ ସାଙ୍ଗେ ରହିଲେ ଖାଇଲେ ପିଇଲେ ଖାଇବା ପିଇବାରେ ଖର୍ଚ୍ଚ ହେଇଗଲା ବହୁତ ଟୋଟାଲ ଖର୍ଚ୍ଚ 10 ଲକ୍ଷ ଟଙ୍କା ହେଲା ଫ୍ଲାଇଟ୍ ଟିକେଟ ହେଲା 5 ଲକ୍ଷ those are besides the issue. I am just giving you example because whenever I direct filing of affidavit, then a essay is written. Don't write a essay, one paragraph.
I will not write any essay, my lord. I will give all the documents also.
Yes, ଆପଣଙ୍କର କେବେ ଅର୍ଡର ହେଲା ପେମେଣ୍ଟ ପାଇଁ ଟୋଟାଲ ଆମାଉଣ୍ଟ ଡ୍ୟୁ କେତେ ଆପଣ ତାପରେ କେବେ କେବେ ଦେଇଛନ୍ତି କୋଉ ମୋଡରେ ଦେଇଛନ୍ତି
But in the meantime, distress warrant might be stayed, my lord.
No.
Distress warrant lies.
No question, sir.
ମୁଁ ତ ପେମେଣ୍ଟ କରୁଛି ସେ ମାନେ ଆନ୍ତି
ସେଟା ସେଇ କୋର୍ଟରେ କହିଦେବେ Sir, don't think that I have come from sky and stood here. I am also a lawyer. The best defense before the executing court is satisfaction of the decree. You show the trial court, and then the trial court does not. If proceeds, then come here.
My lord, I am saying that part payment may be allowed.
No.
The mode of payment is
bargain challenge. Bargain challenge. Go and tell the executing court that you have paid this much. Let the court pass order. Sir, you are not the agent of the client. You are a lawyer. ଆପଣ ଯେତେବେଳେ ଆସି ହଜବେଣ୍ଡ କହୁଛନ୍ତି ମୋର ଦବାର ନାହିଁ କେସ୍ କରନ୍ତୁ ତା ବ୍ରିଫ୍ ଫୋପାଡ଼ି ଦିଅନ୍ତୁ ତା ମୁହଁକୁ
ନାଇଁ ମୁଁ ଦଉଛି ମାଇ ଲର୍ଡ
ସେଟା ଏକ୍ଜିକ୍ୟୁଟିଭ କୋର୍ଟରେ କୁହନ୍ତୁ ଆଜ୍ଞା ଆପଣ ଯୋଉଟା ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ଦଉଛନ୍ତି ସାଟିସ୍ଫାକ୍ସନ ଅଫ ଏ ଡିକ୍ରି ଆପଣ ଏକ୍ଜିକ୍ୟୁଟିଭ କୋର୍ଟରେ ନ କହିକି ଆସି ହାଇକୋର୍ଟରେ କହୁଛନ୍ତି
ସେଇଟା ବହୁତ ହାୟର ସାଇଡରେ ହେଇଛି ବୋଲି ମୁଁ ହାଇକୋର୍ଟକୁ ଆସିଛି ମାଇ ଲର୍ଡ
ଆପଣ ତ ଶୁଣିବେନି ଆଉ ଆପଣ ଯାହା ଦଉଛନ୍ତି ଏକ୍ଜିକ୍ୟୁଟିଭ କୋର୍ଟରେ କହିବେ ମୁଁ ଏତିକି ଟଙ୍କା ଦେଇଛି ବୋଲି ଡିଷ୍ଟ୍ରେସ୍ ୱାରେଣ୍ଟ ଆରେଷ୍ଟ ନହେଲେ ଆରେଷ୍ଟ ହେଇ ରହିବେ
That is already admitted by the opposite petitioner also.
Yes, କଣ କହିଲେ ସେଠି already ଦେଇଥିଲେ
ହଁ ସେଇଠି ଦେଇଛୁ ସେଇଟା admitted by the petitioner and rest amount is being asked to me. I said
rest amount deposit କରିବେ
give me some time.
You are before a court who understands a little of law. Not
exactly
much like other courts, but the court understands and reads a little bit of law.
That I understand, my lord.
So don't make these kind of submissions that ମୁଁ ଦେବି ଆପଣ ଟିକେ stay କରିଦିଅନ୍ତୁ so court କହିବେ ଦେବେନି arrest ହୁଅନ୍ତୁ
part payment ଗୋଟେ ମୁଁ ଦେବି
part payment ନା part payment କୋଉ provision ରେ ଅଛି
financial capacity ବି ଦେଖିବାର ଅଛି
financial capacity ସେଟା matter of proof and evidence financial capacity you have to prove before the court that you are alive or court decision ପଢିଛନ୍ତି
that has been not considered by the trial court.
সেটা আপন সিকিউর করন্তু দেখিবা
সেটা at the মানে হিয়ারিং I will show it.
এটা ওরালি হবনি আজ্ঞা নাই ওরালি হেই পৰিবনি আপন হিয়ারিং কলে করিবে সেমতি ওরালি কहिले যে এটি আজ্ঞা মু প্রুভ করଥିଲି আপন বর্তমান যদি মু হিয়ারিং করিবে আপন ম্যাटर ডিসমিস হইଯିବ that I am sure.
নাই my lord more income tax pay.
Mr. Moon, you are the conducting counsel there. ट्रायल रे की थिले आपण ट्रायल करथिले
मु थिले आमे
सुनंतु पहिला पूर्व सुनंतु प्लीडिंग पढिबे रिटन स्टेटमेंट पढिबे डिपोजिशन पढिबे जोटी आपण से प्ली नेचंती देखैबे तापरे कोर्ट को डिस्कशन करछन देखैबे दैट इज एनफ आ अधिक परिश्रम करे दरकार नै
इन द मीन टाइम मते किछि रिलीफ देंतु माय लॉर्ड
नै मु रिलीफ बाटे पे बसिनी मोटी जस्टिस करे पे बसछि
My lord, listen to me.
Relief bata houni. Justice.
My lord, टिके सुनंतु मु गोटे इनकम टैक्स पे भी न है ताकु 50,000 गोटे पनिशमेंट टाइप मो 2019 रे मोर इनकम गुडा को थिला
50,000 टा 1,50,000 भी जाई पारे सेटा दैट्स एठी आगा रिलीफ बंटा होनी जस्टिस बंटा होची
हायर साइड लोअर साइड रे टिक करले माय लॉर्ड
हेई परिबन आपण जदी आर्ग्यू करिवे भी आई एम रेडी टू हियर बिकॉज़ आई नो द वे यू आर सबमिटिंग यू हैव दिस
because
income tax pay हेतले को केस लॉ रे पढिले income tax pay देबे न हेतले देबेनी बोली ट्रायल कोर्ट रे को डिसीजन ता पढि आर्ग्यू करथिले
माय लॉर्ड मोर इनकम कैपेसिटी अनुसार त
माय लॉर्ड जे आपण जोडा पॉइंट आर्ग्यू करछंती को डिसीजन पढि आर्ग्यू कले
डिसीजन इट इज कॉमन सेंस दैट माय इनकम कैपेसिटी शुड बी कंसीडर्ड दैट इज नॉट कंसीडर्ड
common sense, all common sense is not law, sir.
I'm not saying.
Law appeals to common sense.
Yes, my
Sir,
lord.
that is the problem. You have argued the matter on common sense without going through the case law or the provision.
Documents also I feel. ଆମେ ଡକୁମେଣ୍ଟସ ଦେଇକରି ବି ଫାଇଲ କରିଥିଲୁ
ସେଟା ଡକୁମେଣ୍ଟ ଆଜ୍ଞା କୋର୍ଟର କାମ ନୁହଁ ଆପଣଙ୍କୁ ଡକୁମେଣ୍ଟ ଦିଅନ୍ତୁ ମୁଁ ଦେଖିବି ଆପଣ ସେଟା ଆଡ୍ୟୁସ କରିବେ
ବିକଜ ସେ ଓନରସିପ ଗୁଡାକ ଜେରକ୍ସ କପି ତାକୁ
ଠିକ ଅଛି ପଢି ନାହାନ୍ତି କୋଉ ଡିସିଜନ ଟା ଶୁଣିଛନ୍ତି ଏ ପଏଣ୍ଟରେ
ନାଇଁ ମାଇ ଲର୍ଡ ମୋର ଡକୁମେଣ୍ଟସ ଗୁଡାକ ସେ କନସିଡର କଲେନି ସେଇଥିପାଇଁ ମୁଁ ଆସିଲି ଏଇଠିକି 2019 ରେ ମୋର ଗୋଟେ ବସ୍ କେତେଟା ଥିଲା ସେଟା ଟ୍ରାନ୍ସଫର ହେଇନି କିନ୍ତୁ
ଆଜ୍ଞା କୋର୍ଟରେ ଗପା ଯାଏନି एविडेंस एड्यूस करा जाए प्लीड करा जाए रिटन स्टेटमेंट किया जाए आ आपण को डिसीजन पढिले एटा जो आर्ग्यू कले जे आज्ञा कॉमन सेंस को डिसीजन रे अछि
मोर सबमिशन हला माय इनकम कैपेसिटी ऊपर ଗୋଟେ ऑर्डर हवा कथा माय लॉर्ड दैट इज ओनली माय सबमिशन
एटा आज्ञा डिसाइड हे जायछि सेटा सुप्रीम कोर्ट रे हे जायछि सुप्रीम कोर्ट डिसाइड
कोर्ट देखली मोर कैपेसिटी जे मोर किछि ओनरशिप किछि प्रॉपर्टी नाही ओनली गुटे रेंटेड हाउस अछि सेटा को मु देखैली
हियरिंग करिवे डिसमिस हेले चलिबो करिवे मु कर सारी देबी
नाही नाही माय लॉर्ड आई एम नॉट
कहि जान ताल ठीक अछि ताल जदी आपण तेति कॉमन सेंस छाडंतु एठे पढंतु पढिबे चारटा डिसीजन पढि परिबे
देबी मैडम माय लॉर्ड मु नेक्स्ट
मु जोटा कहबी काना प्रॉब्लम होछि जे आपण जा पढिथिबे सेटा हेइ नथियो से पॉइंट रे डिसीजन उडा के देबी पढिबे पढि के आसीबे
हां आसीबी माय लॉर्ड
आपण कोटा कोटा कोंतु मु भी पढिबी कोंतु को डिसीजन
I will get prepared. Admission पे आइछि माय लॉर्ड
कौन केस करि गलानी तापर प्रिपेयर हारि गला परे
ऑपोजिट पार्टी अपियर कला परे मु प्रिपेयर हे करी
नहीं आपण जोटा ट्रायल कोर्ट रे कले को केस आर्गुमेंट कले साइड कले सेटा कोंतु मु भी पढिबी ना
ट्रायल कोर्ट मु डिसीजन देनी माय लॉर्ड ट्रायल कोर्ट डॉक्यूमेंट्स देलु डॉक्यूमेंट्स थिला सेटा हम देलु
सर एवडे रिकॉर्डिंग होछ आपण ट्रायल कोर्ट डिसीजन देने जो रिकॉर्डिंग हे रहि गला YouTube रे
सेटा देनी माय
सर फुल सेट बिना कहवा बंद करंतु ठीक कहवा बंद करंतु जदी यू आर सो कैंडिड यू आर सेइंग ट्रायल कोर्ट रे किछि डिसीजन साइटेशन देइ नांती कॉमन सेंस कले वर्तमान लेखंतु कलम धरंतु लेखंतु
कोंतु
रजनीश वर्सेस नेहा कलम भी नहीं ना अछि
अच्छा कोंतु माय लॉर्ड
रजनीश वर्सेस नेहा
रजनीश जानि
into bracket 2021 bracket close 2 SCC 324
ठीक
आपण कोन बही देखिबे ना कोन ऑनलाइन देखिबे
ऑनलाइन देखि देबे मैं
अछि एससीसी ऑनलाइन हाई कोर्ट देछि जो लाइब्रेरी को पढुचंदी
हां देखि देबे
एटा को जगह कलाहाटी अछि कलाहाटी
अछि मान
आउडे पढिबे शमीमा फारूकी वर्सेस शाहिद खान
शमीमा
फारूकी वर्सेस शाहिद खान
हां यस मान
into bracket 2015 5 SCC 705
ठीक अछि
ए दीटा पढंतु एटलीस्ट ए दीटा न पढी के ब्रांच रे प्रैक्टिस करंतु नहीं
ठीक अछि
you must understand there is a hierarchy of courts supreme court has issued guidelines regarding these matters under article 41 42 141 and directed that it should be circulated throughout India all high courts all district courts website agote ache execution guideline अछि execution रे decision अछि how the execution is to be handled अपन ऑर्डर टा केबे हेला ऑर्डर टा केबे हेला डेट ऑफ ऑर्डर
ये ऑर्डर एवॉर्ड माय लॉर्ड 25/8/2025 रे
so it has some guidelines also anyway सेटा परे देखिबे ए दिटा पढिला परे ब्रांच रे प्रैक्टिस करन
मतलब डायरेक्शन
आपनकर जोटा शमीमा फारूकी इट्स ए रिवीजन रो स्कोप आपनकर जो आपण प्रूफ एंड ऑल दैट एटा ओल्ड डिसीजन अछि बहुत पुराना डिसीजन भी अछि बट एनीवे यू सी दिस
କିନ୍ତୁ ଟ୍ରାଏଲ କୋର୍ଟକୁ ଡାଇରେକ୍ସନ ଦିଅନ୍ତୁ ମୁଁ କେତେ ଡିପୋଜିଟ୍ କରିଦେବି ଆଉ ତାପରେ
ଆପଣ ସାର୍ ସେଟା ମୁଁ ଏଠି ଆଜ୍ଞା ମୁଁ ଏଠି ବସିନି ଲୋକଙ୍କୁ ଡାକିବି କହିବି ଯେ
ଅଲରେଡି ସାର୍ ଅଲରେଡି ସେ
ଆପଣ ଯାହା ଦେବେ ଆଫିଡେଭିଟ ଫାଇଲ କରିବେ ଆଜି ଯଦି ଦେବେ କାଲି ଲିଷ୍ଟ ହବ କାଲି ତ ହବନି ନେକ୍ସଟ ୱିକରେ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଆଫିଡେଭିଟ ଫାଇଲ କରନ୍ତୁ କୋଉ ଦିନ ଦେବେ
ସେ ୱାରେଣ୍ଟ ଟା ଟିକେ 2 ଦିନ ସସ୍ପେଣ୍ଡ
ହେଇପାରିବନି ଆଜ୍ଞା ତାକୁ ଆଜ୍ଞା ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ସାଇଡ୍ ରେ କୁହାଯାଇଛି ସୁପ୍ରିମକୋର୍ଟ କହିଛନ୍ତି ମ୍ୟାଟର କାହିଁକି ପେଣ୍ଡିଂ ଅଛି ସେଇ ଡିସିଜନ କୁ ତ ମୁଁ କହିଥିଲି ସେ ମ୍ୟାଟର କାହିଁକି ପେଣ୍ଡିଂ ରହିଛି ମୁଁ ଆଇ କାଣ୍ଟ ଚେଞ୍ଜ ମାଇ ଷ୍ଟାଣ୍ଡ କଲର ଚେଞ୍ଜ ମାଇ କଲର ଏଠି ଆଜ୍ଞା ଜଷ୍ଟିସ ବଣ୍ଟା ହବ ଏଠି ରିଲିଫ ବଣ୍ଟା ହଉନି
because we are already paying towards the educational expenses of the son.
Don't attribute your personal knowledge. ଆପଣ ଜାଣିଛନ୍ତି ସେ ଦଉଛନ୍ତି suppose even I know Mr. Moon, if suppose even I know that he is paying, I cannot because you have to bring it on record.
I have filed it on the all the documents in the court, trial court, my lord. Trial court
ସେଟା ଆପଣ ଏଠି ରିଭିଜନାଲ କୋର୍ଟରେ ବି ଫାଇଲ କରନ୍ତୁ
madam, my lord.
ଏଠି ବି ଫାଇଲ କରନ୍ତୁ
ଇଣ୍ଟରିମ୍ ଦେଇଥିଲେ ଭଲ ହେଇଥାନ୍ତା
ନଦେଲେ ବେଶୀ ଭଲ when the husband the wife child ଅଛନ୍ତି ନା ନାଇଁ
child କୁ ତ ଦଉଛୁ my lord child
wife and child have been awarded a maintenance
ସବୁ
ସେତେବେଳେ ଦେଇକି stay ନ କରିବାଟା ଭଲ
child ର ସବୁ ବେଶୀ କରୁଛୁ ଗୋଟିଏ ପଇସା ବି ସେ ପିଟିସନର ନମ୍ବର 1 ବିୟର କରୁନି ଆମେ ଏକା ବିୟର କରୁଛୁ ପିଟିସନର ନମ୍ବର 1 ର ଖାଲି ଆମେ
ମାନେ ଆପଣ କେତେ ଜଣ ହଜବେଣ୍ଡ କି
ମାନେ
ଠିକ ଅଛି
ମାଇସର କେତେ ଜଣ ପଡୁଛି
ଆମେ ବି
hello ମୋର କହିବା କଥା ଆମେ ଯେହେତୁ ପେମେଣ୍ଟ କରୁଛୁ ସିନସିୟରଲି we are looking after my son that's why I am saying that
ସେଟା ଆପଣ ଏଇଟା କଣ ଆପଣଙ୍କର ଡିବେଟ କମ୍ପିଟିସନ ରେ ପାର୍ଟିସିପେଟ କରୁଛନ୍ତି ନା କଣ ଏଟା ଆପଣ କୋର୍ଟରେ ଆପିୟର କରୁଛନ୍ତି ଆପଣ ଷ୍ଟେଟ ପେଜ କୁ ଯାଆନ୍ତୁ କୋଉ ପେଜ ରେ ଆପଣ କୋଉଠି ଦେଇଛନ୍ତି ଏଭିଡେନ୍ସ
ନାଇଁ ଅଲରେଡି ଏଫିଡେଭିଟ ରେ ଦେଇଛି ସେଟା ଆଉ ଫ୍ରେଶ ଏଫିଡେଭିଟ ଦେଇଦେବି
ଫ୍ରେଶ ନାହିଁ ଫ୍ରେଶ ନୋ ଷ୍ଟେଲ ଆଫିଡେଭିଟ ଯୋଉଟା ସେଠି ଫାଇଲ କରିଥିଲେ
ମୋ ପ୍ଲିଡିଂ ରେ ଲେଖିଛି ମାଇ ଲର୍ଡ ସେଟା
କୋଉ ପାରାଗ୍ରାଫ ପ୍ଲିଡିଂ କୋ
ଏଥିରେ ଖାଲି ବ୍ରୋଡଲି ଲେଖିଛି ମାଇ ଲର୍ଡ ଯେ ମୁଁ
ଆପଣଙ୍କ ଡିଫିକଲ୍ଟ ହେଲା କହିଲେ ଆପଣ ପେପର ଖୋଜିଲା ବେଳକୁ ମୁଁ ପଢି ସାରିଲିଣି ଆପଣ ଯୋଉ 13ଟା ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ରେ ସେଟା କିଛି ଲେଖି ନାହାନ୍ତି
ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ତ ସେଟା ଲୋଅର କୋର୍ଟ ଟ୍ରାଏଲ ବେଳକୁ ମ୍ୟାଡମ
ସେଇଥିରେ ଲେଖି ନଥିଲେ ଏଠି ହବନି for the matter is mentioned matter being in the list is mentioned by the learned counsel for the petitioner after end of the Mr. Baisak, you are appearing here?
No.
So kindly take your seat. Is mentioned by the learned counsel for the petitioner appearing in VC to be taken up after the special bench at 2 p.m. was over. Though the days are over, the matter is taken up considering the mention made by the learned counsel, Sri Rajendra Kumar Moon, who is present at the virtual court, High Court of Orissa at Kalahandi. It is submitted by the learned counsel for the petitioner. The petitioner husband is before this court. Challenging the judgment and order dated 25/8/2025 passed by the learned judge Family Court Patna in CRL.P. number 29 of 2024. The said petition was filed under section 125 of CRPC by the wife in the marriage and the minor son born from the wedlock, seeking a monthly maintenance of rupees 1,50,000 and cost of litigation. In the petitioner, it is alleged the opposite party husband relationship with a lady he keeps neglecting the wife and the child in the marriage. The minor child suffers from disease which requires at least rupees 5,000 per month. The disease is chronic collar ulcer. The opposite party husband before the Lord Judge Family Court only the opposite party filed his written statement. The petitioner adduced evidence appearing as the witness, the petitioner wife. The opposite party husband adduced evidence of two witnesses. Thirty-five documents were exhibited on behalf of the claimant wife and 2 documents were marked as exhibits on behalf of the opposite party. To challenge the order in revision, it is submitted by the learned counsel for the petitioner that the amount of rupees 50,000 directed to be paid as monthly maintenance is in the higher side. The petitioner takes care of all the expenses of the child. Petitioner husband herein takes care of the expenses of the child, and the said fact has not been taken up. It is further stated that the petitioner husband is not an income tax assessee, and that should be a ground. That should have been a ground to be considered by the learned Judge Family Court while granting the maintenance. Since the capacity to earn and the expenses incurred towards maintenance of the son are matter of pleadings and evidence, the learned counsel for the petitioner husband was asked to point out from the written statement filed before the learned family court, where he has made such statements. The learned counsel has no answer. Perusal of the written statement, which is annexed to the copy of which has been annexed to the petition, does not disclose any such averment. But in view of the law laid down by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, citation given, authoritatively dealing with the power of revision of this court, of High Court, in dealing with the orders of the family court, particularly in the matters like the present petition pertaining to section 125 CRPC. The petitioner before this court has to show from the pleadings as well as evidence that the case is made out for revision before this court. Regarding the earning capacity as well as the amount of expenses incurred by the husband towards maintenance of the wife and the child, material has to be brought before the learned judge family court, and the petitioner has to show before this court that such material was placed on record by way of pleadings, evidence, deposition, exhibits, pleading, evidence, deposition, exhibit. Stop. The learned counsel for the petitioner is also apprised of the decision rendered by the Honorable Supreme Court in Rajneesh versus Neha, holding that the amount of maintenance directed to be paid is in the nature of a money decree. The petitioner has to secure the amount for sustaining the challenge. The learned counsel for the petitioner and has adjournment to obtain instruction and file affidavit on behalf of the petitioner if so advised. Yes. Kebe asile haba, Mr. Moon?
Next week, my lord. Next week I'll bring.
List in the week commencing.
Date adjourn दे देना.
4-5. Week commencing 4. Yes. Any other matter from the first list? Okay. Upon Mr. Baisar, can you go to
Item number 14, this is not my matter.
14.
The face solution matter, the next week is.
Item 14 of the first list. Upon date करथिले earlier not. Upon the mention cordial function.
Either item
Just गोटे करी सर.
We concern 4-5.
4-5 रा आपणकर सर.
item number 19 will take on upon Monday.
ए बॉन्डे ही परिबोनी. स्पेसिफिक सेंट करी हो. सब 6%. 19 सर छुट्टी पूर्वरु जाउछ ना छुट्टी परे. छुट्टी पूर्वरु सर. 19 छुट्टी पूर्वरु गोटे डेट करिवे.
We concern 18-5.
Item 9, your lordship.
After notice sir पडिबोनी because things have not now become
Pleading set complete.
Yes sir, but it has to reach. Kindly mark the first matter is 2016. Computer जो entry होची 16 matter ऊपर को पड़ेगा. As the first matter थिला to be mentioned है कि hearing है ला 1 घंटा 15 मिनट. कौन करा? Yes,
Item
Mr.
9. Item 9. Item 9 may be taken up.
आपण 9 टारे कॉपी आगे दे दियंतु स्टैंडिंग काउंसिल देइछथि.
Item 9, your lordship.
मु से कहूची आइटम 9 रे आपनकर अपोजिट पार्टी रो स्टैंडिंग काउंसिल को देइछन्ती कॉपी.
No, my lords.
देइ देबे ना so that at least the matter can be taken up. Item 9 टा केबे रखियो फ्रेश एडमिशन. Standing council को दियंतु. Do you know the standing council or do not
sorry.
have a standing council?
No, I do not know. I'm sorry.
ठीक अछि अब ये साइसी रो स्टैंडिंग काउंसिल होचंती अमरेंद्र प्रसाद रे. Right. अमरेंद्र प्रसाद रे.
My lords.
ताका आसु दिजो से सब दिन आज भी कोर्ट रे थिले आपण कोर्ट को आसु नांती हो.
Your Lordship, item 27.
My lord,
27.
27. Next week रे पहुंचंदी आसियो बोली
Next week, Your Lordship.
आसी पारे.
My lords, next week.
My lord, item number 8.
Your Lordship, first week. First week of
आया
27.
केबे चाहूछु.
First week of
After notice.
After notice matter का अपन जो घट थे कौन देखो. My lord, item number 8. Just 1 second, sir. 1 second. My lord, just give me a second, sir. Give me a second. 27.
18/5.
We comment on 18/5. Yes, item 8. Samanti.
It is fresh admission matter.
Correct, sir. The page is over since 1:15. I sat till 1:40. Now it is 4:40. So it can be given a date. आपण चाहूचंदी छुट्टी पूर्व की परे कहले डेट हबो. My lord, छुट्टी आगुरु. ठीक अछि. Item 8 करो.
We commencing 4/5.
We commencing 4/5. My lord,
Item number 6.
yes. आपण भी लिस्टिंग चाहूचंदी. फ्रेश एडमिशन में 6 टा कर दियो.
We commencing 4/5.
We commencing 4/5. Yes.
Item 33.
Sorry, sir.
32.
32 चाहूचंदी. 32 तो आपण କହିଥିଲେ बोले से मार्क करथिले ना को.
No, mark करते एची जो को डेट करे.
32 आपण छुट्टी पूर्व ना परे सर. छुट्टी परे.
We commencing 13/7.
13/7 week. 2 weeks after the reopening. Yes.